Hello students, welcome to Recital Plus, your syllabus aligned current affairs session. My name is Harshit Johari and in this session we will not just read news but we'll also decode it for you. For your better understanding, I will be helping you with some of the PYQs as well as some practice questions. So in this manner, you will be able to understand the news better and also you will be able to revise the whole recital in the most efficient manner. Students, today the topics that we'll be discussing is social issues, polity, and in part 1 other subjects would be covered. So let's start with the social issues, and these are the major topics that we'll be discussing for today. Moving to the first news, like Viksit Bharat Shiksha Adhishthan Bill 2025. So what is happening? Government of India has came up with a bill for the overhauling of the higher education institutes by replacing UGC, AICTE and NCTE with a new umbrella commission in order to justify the workload. Alright, the core objective of the Viksit Bharat Shiksha Adhishthan Bill is that it will enable and empower universities to achieve excellence, teaching, learning and research and innovation. That is the primary objective. And it will also provide a unified governance mechanism for higher education. Moving to the next, there is a commission which will have some 12 members and it will also have 3 councils. For example, the regulatory councils, accreditation council and standard council. This provision is in sync with the new education policy's light but tight approach. That means they will reduce the bureaucratic complexity, but they will increase the accountability purposes. All right. This proposed law will apply to all central state universities, college and higher educational institutes, institutes of eminence, institutes of national importance, and also technical and teacher education institutes. However, you please note that professional programs such as medicine, dentistry, nursing, law, pharmacology, veterinary sciences are exempt and will continue under their respective regulators. So that will not be covered under Viksit Bharat Shiksha Adhishthan Bill. When it comes to architecture, the Council of Architecture will remain a body for professional standard setting, but it will not have any regulatory power. So these are the changes that have been introduced in the bill. Some other changes if we see. So first of all, as I just mentioned, it will replace the existing bodies UGC, AICTE and NCTE will make a single body. Separation of funding from regulation. The major development is this, that this bill will remove the grant dispersal power of the UCG and now this would be done with the Ministry of Education. Alright, enhance institutional autonomy. For example, shift from micromanagement to self-government. The regulator will act more like a facilitator. Now, outcome-based evaluation framework. Now, in this bill, they are preferring quality over quantity. For example, input-based UGC norms, for example, infrastructure, student count, teachers, they will focus on learning outcomes, student skill, employability, societal and real-world impact. So that is a change from quantity to quality aspect. However, there are some critics. Challenges is that, first of all, it might give center an upper hand and it will erode the federalism. Removal of grant dispersal power from an autonomous body is also a concern. However, the bill tries to done away with the question of the weakening of federalism by giving representation of state in all 3 councils. However, this issue we will be looking for once this will executed. Alright, graded penalties for enforcement mechanism. The body will have the punitive powers also. So fines beginning from rupees 10 lakh to up to 75 lakhs. Possible closure of institution for repeated non-compliance. Power to suspend an institution authority to grant degrees or diplomas, and also institutions operating without accreditation may face fine up to 2 crores. Alright, so this is all about the Viksit Bharat Shiksha Adhishthan Bill 2025. You see, questions related to the bills are very often asked in the examination. It was asked in a PYQ, and for that I have a prelims practice question for you, and let's see, consider the following statements regarding the Viksit Bharat Shiksha Adhishthan Bill 2025. The bill proposed to replace the UGC, AICTE and NCTE with a single umbrella body. That is correct. We see these 3 bodies would be subsumed. This is a correct statement. The bill applies to professional programs such as medicine, law and dentistry. This is an incorrect statement because I have mentioned that these professions, for example, dentistry, medical, will remain under the current regulator only. Right? The bill emphasizes light but tight regulatory approach structured in line with new education policy of 2020. So this is an incorrect statement. Answer would be 1 and 3 only. Right? Now, let's see a mains question. For example, skill development is very, very important. It was asked in the mains PYQ, this theme. Have succeeded in increasing human resource supply to various sectors. In this context, the statement analyze the linkages between education, skill and employment. Now, when it comes to the linkages with education, now you can mention the Viksit Bharat Shiksha Adhishthan Bill, which tried to promote the quality in the education sector especially. Right? Now, we will have a mains question also, discuss the key provision of the Viksit Bharat Shiksha Dishtan Bill and evaluates its potential impact on the regulatory framework of higher education in India. So what are the changes? First of all, it will promote autonomy, light but tight, all right, approach with respect to, that means bureaucratic hurdles are reduced and accountability measures have been strengthened. Also, it will promote quality of education, employability. So these are some of the provisions that are in this act. On these lines, you will be able to write this answer. Do try this. Now, the next thing is the child marriages in India, and this is something that Government of India has started 100-day awareness program to mark 1 year of Bal Vivah Mukt Bharat Abhiyan. Now, what is this important? Because though in India, if we see, child marriage is related to this SDG goal 5, right? In India, there's a decline. There was a sharp decline, but now more or less things are stagnant. If we see sharp decline, 47.4% in 2005, and then 26% in 2016, that means steep fall of 21 points. However, after that, it has remained more or less stagnant, right? You see, it's 23.3%. So, and it is also, there's a lot more disparity in terms of regional. For example, you see West Bengal, Bihar and Tripura have the highest prevalence of the child marriages in India. On the contrary, Lakshadweep, Jammu Kashmir, Ladakh and Himachal Pradesh have the lowest numbers. All right. Now, also it has a socio-economic indicator as well. If we talk about the education, so the girls, up to 50% of them who have no education are married early. Similarly, if we see like the girls from the poor household, 40% of the girls are married early against 8% of the richest people. So this is like regional disparity, also socio-economic indicators, education and income criteria is also related to that. Now, tackling child marriages in India, what government is doing, what are the steps taken by Government of India? So let's see, Prevention of Child Marriage Act 2006. This was introduced in 2006, after which child marriage rates were halved, as I just mentioned, from 47% to 26.8%. But after that, it's more or less stagnant. Then government came up with the POXO Act in 2012 to strengthen the protection. After that, there were not much progress in this regard. Hence, it is being stated that laws may have a very limited scope when it comes to a social change. It is actually the culture of society. So for that, to bring the awareness among the masses, government have started this abhiyan, this campaign, right? Apart from that, what government is doing, government has empowered some welfare scheme, for example, Beti Bachao, Beti Padhao, for improving child sex ratio and girls education, and also state level incentives. For example, West Bengal's Kanya Shri scheme. We know West Bengal has one of the highest prevalence of the child marriages. Hence, in order to avoid that, government has came up with the Kanya Shri scheme, where they will give a lump sum amount of money in case the girl is married after attaining the age of 18. Alright, so what is the outcome of this abhiyan if I tell you? So around 54,917 officers related to child marriages prevention officers have been appointed nationwide, and some around 1,520 marriages were stopped. Okay, so there are some positives, but yet a lot of ground needs to be covered. Now, debate on raising the legal age of the marriage for women. We know Jaya Jetli Commission tried to stated that women it should also be increased to 21 from current 18 years of age. However, critics question that without parallel social reforms, if there's no awareness among the people and if you increase, then large section of society would be under criminal this act, right? Because if there's no social awareness among the people and if we increase the age from 18 to 21, there's a large section of society which would be criminalized under this act. Hence, social awareness is important before going for such campaign, and this highlights the importance of is a Bal Vivah Mukt Bharat Abhiyan. Alright, now based on this, try to solve this question. Consider the following statements about child marriages in India. The Bal Vivah Mukt Abhiyan aims to end child marriages by 2030. Okay, the highest prevalence of the child marriage in India state like West Bengal and Bihar. The Prevention of Child Marriages Act 2006 has led to a complete eradication of child marriages, right? Which of the statement above are not correct? So answer would be 3 only. This is incorrect statement and they're asking for the not correct, so answer would be 3 only, right? Because marriage is a favorite theme of UPSC, and as they have a do you think marriage as a sacrament is losing its value in modern India? On the same lines, I have a mains question for you. Examine the socio-economic factors contributing to child marriages in India and suggest measures to accelerate progress towards its elimination. What you need to do, you have to start with SDG goal 5, right? Then you have to mention the socio-economic factor. For example, we have seen education and income criteria, right? So if we promote education, and also with education, if the standard of life is better, so people tends to have higher age of marriage, so that the prevalence of the child marriage will eradicate gradually. And also that is not solely important. What we have to go for, first of all, we should go for social awareness and also legal protection. For example, the laws that are in place, it must be implemented on reality, right? So that is how you can answer this question. Please do write this. Now moving to the next is the CAG findings of PM Kaushal Vikas Yojana, something very disturbing. So CAG has flagged serious implementation gaps in Pradhan Mantri Kaushal Vikas Yojana in an audit report to the Parliament. First of all, let us see what is Kaushal Vikas Yojana. It is skill development under the Ministry of Skill Development and Entrepreneurship, right? The objective is to enable Indian youth to acquire industry level skills so that the employability could be increased, right? It focuses on short-term training, recognition of prior learning also, and placement support. So there were 4 phases, 1, 2, 3, 4, in which the scheme was implemented across the India. Now, what are the key features of the scheme? If I tell you, free skill training also, and there's a diverse fields. For example, construction, manufacturing, healthcare, electronics, retail, services, and etc. Right, this is an outcome-based funding mechanism. For example, trainings partners are linked to certification and placement. That means the award would be given, the money would be given to training partners once the person received the certificate as well as employment or placement, right? The person who is certified will also get 500 rupees transferred through DBT mechanism. This is all about the scheme. There are some achievements also of the scheme. First of all, it becomes the largest skill development program in the world. Okay, it also, according to official data, 1.32 crore candidates were targeted for the training and certification, out of which 1.1 crore has received. Okay, it has created the nationwide network of the skill development centers, standardizing skill certification, and also promote skills which are required for the organizations and employability industries required. Integration of skill development with Digital India and direct benefit transfer mechanism. This is all the achievements of the scheme. Everything is fine till here. However, CAG in its report has found that invalid bank accounts number, for example 111 and blank field, repeated account numbers for multiple beneficiaries. That means the implementation is not that great. Alright, that means there's a prevalence of ghost beneficiaries is there. About 94% of the candidates, they lacked reliable bank account details. Apart from that payout, that is rupees 500 that was supposed to be received to the person who will get the certificate, more than 34 lakh candidates were pending. However, government has stated that with the inclusion of direct benefit transfer, this would be resolved, but only 18.44% of the candidates received DBT in PM 2.0 and 3.0 as well. Alright, audit also revealed that there are some training centers which are shut. There is no physical presence over there, but shown that ongoing trainings are going on. Okay, the use of identical photographs of multiple benefits across states such as Bihar, UP, MP, Maharashtra, and Rajasthan. Right, so this is the issue that has been raised by the CAG in its report. What are the government reports? Government has responded. The scheme has been significantly strengthened by the time. For example, there are some measures taken by the government. One is now, because there was beneficiary mismatch, right? Same photos, multiple beneficiaries. So government has started with Aadhaar authenticated eKYC, the first thing. Second, they have also introduced face recognition and geo-tagged attendance. Right, QR code digital certificates and enhanced inspection through Kaushal Samiksha Kendras. So these are the steps taken by, and that government claims that these reforms aim to ensure transparency, accountability, and better beneficiary tracking. With the issues that were highlighted by the CAGs has been addressed by the government by taking up these steps as per the government sources. Now for that you have a prelims question. Now let's see. Consider the following statements regarding the Pradhan Mantri Kaushal Vikas Yojana Skill Development Mission. It is implemented by National Skill Development Corporation. So answer is, this is correct. The scheme focuses on skill development solely related to emerging sectors like AI. No, it is incorrect statement. So it is manufacturing, healthcare, electronics, retail, services, construction. So there are multiple things are involved. It focuses on long-term skill training only. It focuses on the short-term training, recognition of the prior learning as well. So correct statement is only one. Answer would be A. Right. Let me tell you the mains PYQ. Development and welfare schemes for the vulnerable, by nature it's discriminatory in approach. Do you agree? Give reasons for your answer. Now you can take up the hint from this article as well. Discriminatory is because the quality which is expected from the services are not provided to the beneficiaries because there are some ghost beneficiaries. For example, the money they are supposed to be received after the completion of certificate is still pending. Okay, so these are the issues that you can highlight from this CAG report as well. Now, analyze the implementation challenges highlighted by the CAG and PM Kaushal Vikas Yojana and propose reforms to enhance its effectiveness. Alright, so we have seen the challenges and the steps taken by the government. Apart from them, you have to propose some more reforms. For example, awareness among the people also, and better implementation of these provisions that are provided by the government. Okay, now moving to the next is Indigo meltdown. I'm sure you all are aware that there was widespread delaying in the flights of Indigo recently. Why it was? The government has implemented some new flight duty time limitation. Because of that, Indigo was the worst hit, because it is the largest airlines which handles up to 60% of domestic traffic and was not adequately prepared. So what is the issue? First of all, massive scale high frequency network of Indigo is one of the cause. Late night and early morning operations, Indigo's on that. And because Indigo is like, they have very less buffer when it comes to crew availability, so extremely high crew and aircraft utilization. And when the flight duty time limitation, that means the relics time, is increased, there was a shortage of crew members to run the aircrafts. So what is the new, this FDTL norm change? First of all, it has increased the weekly rest time from 36 to 48 hours. Okay. Secondly, night landings were capped at 2, down from 6. And I just mentioned that Indigo have the highest number of early morning and late night landings. Definition of night hours extended by 1 hour. Alright. So this all impacted the airlines in general and Indigo in specific. Now, implementation timeline. It was originally provided in 2024 June, right? But then government, industries opposed immediate execution of these. So government has came up it into the 2 phases. Alright, the first phase is a longer weekly rest. Indigo did better here. Phase 2 was strict night time limits. Indigo hit disproportionately over here, right? So Indigo has stated that it was because of some technological issues, the weather, increasing congestion of the aircrafts, and also full implementation of the new FDTL, right? The government has approved one-time exception for now, FDTL norms for Indigo Airbus A320, but they have to ensure that this sort of situation must not create in future again, right? On that, I have a prelims question for you about the Indigo flight disruption. The first primarily due to the new flight duty time limitation norms. That is correct. The revised FDTL norms cap night landing at 6. No, it has reduced from 6 to 2. So this is an incorrect statement. The DGCA granted Indigo a one-time exception for A320 pilots. That is a correct statement. They're asking for not correct. So answer would be A only. Okay, now write down the impact of regulatory changes like FDTL norms on aviation operations in India. Suggest ways to improve aviation operation. The first of all, you have to impact. We have just seen the Indigo meltdown, lack of crew, lack of preparedness, poor experience for the passengers, and all those things. Suggest ways to improve aviation operations is, first of all, it must be awareness, right? Second, prior preparation. All right, then you must have accountability and ensure buffer of crew and required staff. With this, we can ensure that this sort of situation would not happen in the future and aviation industry would run more smoothly, right? So that's all from the social issues. Now we'll be moving to the polity and governance, and these are the topics that we'll be discussing today. Okay, the first one is Sanchar Sathi. Let me tell you what is Sanchar Sathi first before getting into the news. So recently, what happened? That Department of Telecommunication has stated phone manufacturers in India that from 2026 onwards, they have to pre-installed Sanchar Sathi app into the mobile phone. Okay, that was the issue. And when this order came into the public, there was a huge backlash from the public, highlighting that it might erode the right to privacy. Okay, so what is Sanchar Sathi application? First of all, it is a citizen-centric privacy-first portal to help user report suspicious cyber attacks, phishing attacks, for example, and also block and lost devices. So it is a very functional application. Okay, the whole issue was with respect to the lack of consent. Now, key features, it can also help you to user report suspicious calls through WhatsApp calls or from international calls, also verify device genuineness, and also you can block and track your lost mobile phones also. If I tell you about the impact, some around 42 lakh stolen phones were blocked, out of which 26 lakh traced and 7.23 lakhs were returned. 1.43 crores fraudulent mobiles were stopped. For example, you can, from this app, you can also check how many SIMs are registered in your name, and if you have some ambiguity that this SIM does not belong to me, you can flag and it could be blocked. All right. Now, privacy and legal alignment, it works only with user consent, can deactivate, delete anytime this app. Minimal data collection shared only with the law enforcement agency when required. It in sync with the IT Act 2000. Okay, so that means overall it's a functional app. But then what is the issue? There are some key privacy big issues with respect to the application. First off, lack of meaningful user consent. If the app is pre-installed in your phone, that means you have not given to the consent for the government to take up the data. That is the first thing, right? Second is possible violation of fundamental right to privacy, as mentioned in the Puttaswamy case judgment by the Honorable Supreme Court. So Supreme Court stated that for that you must have three grounds. First is legality, second is necessity, and third is the proportionality. And this is the challenge. First of all, it does not have any statutory backup. It was just an executive order. That means it lacks legality. Second, it was not necessary because some better alternatives, for example, web portal through IMI verification through SMS are available. Third is disproportionate. Forcing a government app in every smartphone is a disproportionate as per the critics, right? And also it has some risk of surveillance and function creep. For example, pre-install applications creates a single point of failure in case there is a cyber attack also, first thing. Secondly, because it's a pre-installed app, you might not be aware, and the app requires some very special permissions like that of location, call logs, mobile, SMS, and everything, which shows the functional creep in future, right? Allows system root access concern. Pre-installed apps got better elevated privileges from the operating system also. Expert warn that this may allow over-the-air updates without any permission from the user. Okay, and also we know weak privacy policy and data governance in India is also one of the challenge. In all that background, it also overload legal powers, right? Enabling mandates an app without parliamentary oversight by just an executive action of a Department of Telecommunication also raise eyebrows. Economic and governance concern. For example, pre-installing apps may affect phone manufacturer, operating system architecture, and user trust. Lack of public consultation and secrecy about the directive worsen the situation. This is all about the issue. So that means that app is very useful, but whether it should be installed in my phone or not, it should be based on my consent. That is the whole issue. Government justified that cyber security imperative. There is an increasing number of cyber attacks in India, and the pre-installed app will give accessibility to the users who are not very aware. Right? We know digital illiteracy is very high in India. So government said that pre-installed app will give faster access to those people. Citizen safety, pre-installation ensure awareness and very easy access to the people. Government stated that though the app is pre-installed in the phone, its use is voluntary. You are not required to mandatory login. You may uninstall it also. So it was completely voluntary. Like it also has a legal basis based on the Telecom Cybersecurity Rule 2025 and expand TIUE framework. Now, good public good rationale. Government stated the idea behind to help block stolen phones, verify connection, and reduce telecom frauds. I have given you data that this was a very highly successful model also. But there are some issues also. So what we need to do, we have to go for the way forward. First, ensure legal basis and transparency. So bring a clear law so that there must be a parliamentary oversight on that. Avoid a voluntary opt-in model. Adopt a voluntary and opt-in model. Let people download if they want. Reduce data permission, avoid taking unnecessary permissions, for example, mobile, location, etc. Strengthen privacy policy, create independent audits from the third party to ensure that there is no functional creep. Functional creep is something that means you have asked a permission for one particular function, say just a reporting of the cyber frauds, but gradually you are increasing your scope. It is more related to the mission creep of China, where they just keep entering and just capturing your territory by every one single mile per interval. Okay, so use less intrusive alternatives like portals, SMS, and IMEI should also be there, and also consult industry and civil society so that fundamental rights as well as the cyber security should go hand in hand. This is all about this article. I hope it is understood now. Now, I have a prelims question. Try this. consider the following statements regarding the Sanchar Sathi app. It requires mandatory pre-installation on all smartphones from 2026. Right? The app enables blocking and tracking of lost stolen phones. It governed under the RTI Act for transparency, and they're asking which one of them correct. So now it is no more mandatory. Government has withdrawn that instructions, and it is not working under RTI Act as well. So answer would be 2 only. All right. Now mains PYQ, if I tell you, now see how we can interconnect the information that we keep adding. This is the skill that you need in the exam. Maybe the exact article would not be asked, but you have to use the pieces of knowledge that you gain in these lectures. For example, keeping in view India's internal security, analyze the impact of cross-border cyber attacks. Also discuss defensive measures against these sophisticated attacks. Now, one of the defensive measures is this application, right? So one of this is this Sanchar Sathi application, where user can report the cyber attacks very swiftly, and the actions could be taken immediate basis as well. That is how you just keep adding the value to your existing notes. Now try to write a mains practice question. Discuss the privacy concern associated with the Sanchar Sathi app and suggest measure to balance security and individual rights. Okay, so what you have discussed the privacy concerns. These are the privacy concerns that we have just mentioned. For example, Puttaswamy case judgment, legality is missing, proportionality is missing, necessity is the missing. All right, and also lack of private data governance in India is a challenge. Measures to balance, these are the measures that you can use. Ensure legal basis. First of all, promote consult industry and civil society. That means stakeholder approach should be taken. Strengthen privacy policy. Adopt a voluntary opt-in model could be the steps that should be taken. On that basis, you will be able to balance the security and individual right. So do try this question. Now, next, very interesting is center's authority over citizenship scrutiny is limited. EC has informed the Supreme Court of India. You must be aware that SIR, special intensive revision, is going in the country in many of the states, and many of the opposition ruled state, for example, West Bengal, Tamil Nadu, and Kerala has challenged this in Supreme Court of India. What is the issue? Opposition allegations are 2. First, it is a backdrop citizenship screening exercise. According to them, this exercise is a disguised form of national registers of citizens. Okay. Secondly, they stated that only the union government has the exclusive authority to scrutinize and determine citizenship, and by claiming the proof of citizenship, EC has bypassed this mandate. There are 2 important issues raised by the opposition parties. Now the matter is in Supreme Court, and EC in its affidavit had stated that the center's authority over the citizenship scrutiny is limited. Now let me tell you how EC has clarified its position. First, stated that according to the Section 9 of the Citizenship Act 1955, which deals with the termination of Indian citizens in case of voluntary and foreign citizenship, it is mentioned that exclusive jurisdiction of union is limited to when and how Indian citizens acquired foreign citizenship. First thing. Secondly, whether these circumstances warrants termination of Indian citizenship or not. According to EC, these are the only 2 grounds according to the Citizenship Act 1955 that center has exclusive jurisdiction over this. Second, according to the Election Commission of India, it exists only for a narrow purpose. If they are asking, because these all aspects related to citizenship can be examined by other competent authorities depending on the context, right? So EC stated that the Union of India has the exclusive authority only based on the Section 9 of the Citizenship Act 1955. Apart from that, it could be from different constitutional bodies based on the case-to-case basis. And for that, citizenship status versus electoral eligibility. EC also mentioned that SIR does not determine or cancel citizenship. It merely accepts citizenship for electoral registration, which is required under Article 326, which restricts voting right to Indian citizens only, right? So that means under Article 326, whosoever is Indian citizen will have the right to vote. And EC is asking whether you are Indian citizen or not, so that it will put you into the electoral list, or otherwise you will be removed. This is what EC stated in the Supreme Court, right? Second, EC also mentioned that there is a constitutional mandate of ECI's authority. According to it, that scrutinizing citizenship for electoral purposes flow directly from Article 324 as well, which grants EC power to supervise and conduct elections, and Article 326, right? And parliamentary laws under Article 327 cannot override or dilute these constitutional powers, which are essential for free and fair election. And it is a constitutional mandate of the EC to conduct free and fair elections in the country. This is what stated by the Election Commission of India in the Supreme Court based on the constitutional provision. However, in addition to that, according to the RPA 1950, the Commission cited that Representation of People's Act 1950, Section 16 disqualifies non-citizens from being included in the electoral rolls, and that is why EC is asking for your citizenship proof. Section 19 requires electors to be Indian citizens and ordinarily resident in the constituency. Section 21, Clause 3 permits SIR when felt necessitates and arise such as outdated or inaccurate voter list. So according to the EC, these are the provisions which gives its power to go for the SIR. Alright, EC also stated that this process is very voter friendly and cooperative. Okay, and also purpose is electoral roll integrity, not exclusion among the people, and to maintain purity of electoral rolls, a prerequisite free and fair elections, which would be the basic features of the constitution. According to the Election Commission of India, SIR will ensure free and fair elections in the country, and it is a mandatory step, which is also a basic feature of the constitution, right? So SIR is a constitutional, statutory and limited exercise aimed solely at ensuring accurate electoral rolls. This is what EC has maintained in the Supreme Court of India. Now we have to wait and see for the judgment by the Honorable Supreme Court. Now you see, constitutional bodies are very much in the UPSC exam, and EC is also one of the constitutional body. So be prepared for that. Now I have a prelims practice question for you. Consider the following statements about the Election Commission's authority on citizenship. The centre's power is limited to cases of voluntary acquisition of foreign citizenship. That is a correct statement. SIR exercises determine citizenship status. So EC has explicitly mentioned that it is not determining or taking away the citizenship right of anyone. Article 326 restrict voting rights to Indian citizens only, and this is a correct statement. So answer would be 1 and 3 only, right? Now, to enhance the quality of democracy, it's a mains PYQ. To enhance the quality of democracy, Election Commission of India has proposed electoral reforms in 2016. What are the suggested reforms and how far they significant to make democracy successful? That means electoral reforms, whenever they are taken, this is very often that they might come in the next exam for sure. Based on that, you must prepare, analyze the constitutional limits on citizenship, scrutiny by the Election Commission and its implementation for electoral integrity. Based on the SIR, you have to write this down. So what they're asking, constitutional limit on citizenship scrutiny. This is what the issue raised by the opposition parties in the Supreme Court. Now you have to mention the powers of Election Commission under Article 326, Representative People's Act and Citizenship Amendment Act 1950. Alright, with its implementation for electoral integrity and why it is important to ensure the free and fair elections in the country. Okay. Now, so Supreme Court has highlights lapses in payouts, critical care for acid attack victims. What is happening? Supreme Court is reviewing a PLA claiming that many acid attack survivors have not received the full 3 lakh compensation and are being denied free treatment despite repeated judicial directions. What is the case background? It was started in 2006 when Supreme Court took up the suo motu cognizance after Lakshmi's assault, and it marked the continuous judicial monitoring on acid attacks cases. First, they have come up with a direction in 2013 and 2015. Compensation framework, 3 lakh rupees compensation, 1 lakh within first 15 days, rest within 2 months. Regulation of acid attacks, that means ban on the over-the-counter sale of the acids. Third, institutional mechanism, district legal service authorities are designated as criminal injuries compensation boards. Grievance redressal was that survivors allowed to approach legal service authorities for delays with respect to the payments, and this is reiterated in the Supreme Court again. Apart from that, free medical treatment is also provided in the private hospitals as well. According to Supreme Court guidelines, private hospitals also cannot deny the treatment. If they deny, there's a criminal liabilities on that. So these were the directions given by the Supreme Court. However, persistent issues highlighted before the Supreme Court first is like non-payment of full compensation. States like Maharashtra, UP received only initial 1 lakh, no support for costly reconstructive surgeries. First thing. Second, denial of free treatment in the private hospital. They ask upright money, and many of the times the victims are not able to pay for it. Administrative failures also. Many states UT did not file affidavits, submit reports which lacked victim-wise details. Weak monitoring by legal service authority, which was mandated by the Supreme Court of India. Now, NALSA's submission is that 484 crores has been disbursed, but Supreme Court demanded victim-wise and case-to-case basis so that there is no one is left behind. Okay, and now on that premises, Supreme Court has given some new directions in 2025. First, strengthening compensation delivery. Chief secretaries to ensure timely fund flow. Chief secretaries should ensure they will be state government to state legal service authority, and from there district authorities, and from district authorities to the victim. That should be the flow of the fund. Mandated detailed record. As I just mentioned, the NALSA's report, which was submitted in the Supreme Court, lacks transparency. The Supreme Court has stated it must require detailed records, for example, victim names, date of compensation request, date of payment, and pending cases and delays. Apart from that, enforcement of free medical treatment in the private hospital. Principal Health Secretary to ensure all private hospitals comply. Non-compliance can invite criminal liability. Remember, it's a criminal liability. Now, data collection and transparency. NALSA directed to collect and submit detailed information from all states based on the compensation disbursed. All right. Now, please understand that this is not just a charity or some affirmative action. It is a constitutional and legal basis to support acid attack victims as well. First is Article 21, right to life. With dignity includes timely medical care. All right. Article 14, equal protection of the law for vulnerable victims. Article 15, subclause 3, state obligation to protect women. And unfortunately, the majority of the victims of the acid attacks are women. All right. Legal frameworks, CRPC section 375A and also section 396 of BNS, Victim Compensation Scheme, strengthen the Supreme Court's directive. What is the significance of Supreme Court directive? First of all, it's upholding a rule of law. Promotes equality among equals, strengthening victims' right, gender justice, human dignity under Article 21, administrative streamline and deterrence for the private hospitals so that they will not deny the treatment to the victims. However, implementation will remain a challenge. Weak monitoring system, poor coordination across different agencies, for example, secretaries to the state to the district, and district to the victims, and also the data gap in the NALSA. Data provided to the Supreme Court. Persistent illegal asset sale is still very prevalent in the country, and also the judicial lags because of the law, like very high pendency in the judiciary. What needs to be done? First of all, enhance compensation. We know the medical cost is really high. 3 lakh rupees may not be sufficient. So government should create a central fund for the reconstructive surgeries, which are very costly. Second, we must strengthen the enforcement. We must ensure that there will be timely compensation and the treatment should be provided immediately, even in the private hospitals. Digital transparency, we must make a portal under NALSA where there must be a transparency, real-time manner based on the compensation provided, accepted, and the treatment given to the victims. Fast-track courts for the better grievance redressals among the victim. Strict asset sale regulation and holistic rehabilitation of the victims is the way forward. Okay, now let's the prelims question. Consider the following statements regarding acid attack victims compensation. The Supreme Court mandates minimum 3 lakh compensation. Free medical treatment is mandatory in private hospitals. NALSA tracks compensation dispersal. Which of the statements given is above are not correct? So answer would be none. That means all 3 are correct. Supreme Court stated the 3 lakh is the minimum compensation that has to be given to the victim. Free treatment in the private hospital, and NALSA will ensure that the data is collected in the most transparent and efficient manner. Now, what are the continued challenges for women in India against the time and space? There was a mains PYQ. So, by adding the challenges, one is acid attacks and poor implementation of Supreme Court's directives. Right? So you can add this one fodder point for your value addition always. In mains, every point is important, right? So this is what you can pick up from this part in case this is not a separate question. This is how you can use this in the PYQ writing as well to improve your content based on the current affairs, integration of current affairs into the static portion, right? The mains question is that examine the systematic lapses in support for acid attack victims and recommend reforms for effective implementation. The systematic lapses we have just seen. And what are the ways should be taken? This is the way how it could be reformed. All right. So we must increase in compensation amount, strengthen enforcement, digital transparency. Okay. Fast track courts, strict asset sale regulation, and also holistic rehabilitation, and promote the awareness among the masses also. So these acts should be stopped once and for all. Right. The next scheme is related to National Forensic Infrastructure Enforcement Scheme. It's a central scheme. First of all, please remember it's a central scheme. Okay. Now, under the Ministry of Home Affairs, what they are trying to do? Expansion of National Forensic Sciences University, establishment of 9 new off campuses across India, and upgradation of existing National Forensic Science University Delhi campus so that it must provide trained forensic manpower. Why there's a need? First of all, because new criminal laws mandate forensic investigation for offences punishable with more than 7 years of conviction, right? India faces a short of trained forensic experts and need for modern, scientific, timely forensic examination to strengthen criminal justice system. We know the crimes are coming up with the new horizons are increasing, right? And also it is mandatory under the new criminal laws, so we need more manpower and infrastructure as well. So because of that, government has came up with this scheme. What is the expected outcomes? First of all, it will increase forensic capacity and reduce pendency in the labs. For world-class forensic professionals, scientific evidence system, and better preparedness for technology-driven crime and evolving methods. As I just mentioned, that the crimes are evolving in nature. They are no more like the previous crimes. With the emerging of the technology, the crimes are also evolving. We must be prepared beforehand also, right? Now, consider the following statements about the NIFES. It established to aim 9 off campuses of National Forensic Science University. The scheme is funded by Ministry of Home Affairs, respond to the criminal laws mandating forensic investigation. So all 3 are the correct answer. Answer would be 1, 2, and 3. Now, you must practice one mains question for this. Discuss the role of NFIES in strengthening India's criminal justice system in the context of new laws. So you have to put that new criminal laws, write down the provisions that it requires a mandatory forensic investigation for offences punishable for more than 7 years, and for that this scheme will provide much needed infrastructure and manpower, and with the faster resolution of these reports, it may also help in fast track the judicial process. Okay. Now, National Film Heritage Mission. Ministry of Information and Broadcasting stated in Lok Sabha that some 1,469 films amounting to about 3.43 lakh minutes have been digitized so far under the National Film Heritage Mission. What they are trying to do is actually the movies which are important in the regional languages, in the other languages also, they just try to digitize this so that they can protect the heritage of the Indian film industry. Okay, this is implemented by National Film Development Corporation, National Film Archive of India. What are the key components? So they are just trying to promote condition assessment of the reels, 2K, 4K restoration so that it must not be lost. Okay, it saves culturally important films across Indian languages, restore classics to the global standard, and also ensure long-term access for the future generation. About NFDC, NFAI, if I tell you, it is headquartered in Pune, a national custodian of India's cinematic heritage, housing over some 30,000 film titles. So this is very important. What they are trying to do, they just try to digitize the whole heritage so that it must not be lost because of the wear and tear. Now, for the prelims practice question, if I tell you with reference to the National Film Heritage Mission, consider the following statements. The National Film Heritage Mission was launched in 2015 under the Ministry of Information and Broadcasting. So that's a correct statement they're asking for. Yes, they're asking for correct statement only. The mission is implemented by the National Film Development Corporation in collaboration with the National Film Archive of India. One of the objectives of the mission is to preserve, restore, and digitize India's cinematic heritage threatened by the physical decay. The National Film Archive of India is headquartered in Mumbai and function as the nodal agency for national film certification in India. It is not the National Film Archive of India. Hence, answer would be 1, 2, and 3 only. Right. The second very important thing is the need policy to make non-scheduled drugs affordable as per the House panel report. So first, I will tell you this is NPPA. It was established in 1997. Okay, and it's an independent regulator for drug pricing and ensure medicine remains affordable and accessible to the masses. Based on the drugs prices control order, it fixes and revises the prices of the drugs. Right. The Parliament Standing Committees has warned that the regulation of non-scheduled drugs is enabling profiteering. Department of Pharmaceuticals has requested to bring a pricing policy for it. Now, what is the current mechanism? Let me tell you. Scheduled drugs, that means the essential medicines list, have a ceiling price set by NPPA. This list is periodically updated by an expert committee. Ceiling prices can be revised annually based on the wholesale price index, right? Scheduled drugs, that means essential list medicines, there's a ceiling price, okay, and then it could be updated annually based on the WPI, wholesale price index. But NPPA cannot fix the launch price of non-scheduled drugs. This is the challenge. For example, there's a non-scheduled drug. It may be initial price, that means the launching price may be, it could be anything. It may be 100, it may be 1,000, it may be 2,000, and NPPA cannot regulate it. This is the current mechanism. and also it could be increased by 10% per year as well. So significance of the recommendation, now they have recommended that you must bring a policy to curb this profiteering as well. Okay, now significance that it will strengthen health governance, because out of the pocket expenditure is really high in India because of the very high cost of the medicine and treatments, and also promote right to health under Article 21. It will promoting equity, enhancing market efficiency, transparency plus regulated margins, reduced asymmetry in this, supporting India's pharma sector. With this, affordability is the main concern, and if India will remain affordable, it can ensure its tag of pharmacy of the world. Alright, then there are some concerns raised by the PSCs. First is regulatory loophole for non-scheduled drugs, okay, and also excessive markup and profiteering. The profiteering among some drugs raised up like from 600% to up to 1800% is the profiteering in these drug sectors, so that there's much needed policy that it must be regulated. Also, weak monitoring of the online pharmaceutical sales as well. Many of the reports has mentioned that though online platforms are selling the medicines at a lower cost, but the quality cannot be assured. This is one of the issue. So they have ensured that comprehensive trade margin rationalization, strengthening NPPA's regulatory power when it comes to initial launch price as well. So it must not be like anything. Okay. So based on that, we have a prelims question. NPPA regulates prices of the scheduled drugs. Okay. And they're asking non-scheduled drugs can increase prices up to 10% annually. All drugs are under the essential medicine list. Which of them are not correct? So all drugs are not under the essential medicine list. So answer would be 3 only. Alright. Now, beside being a moral imperative of welfare state, primary health structure is necessary precondition for sustainable development. Analyze. This was a mains PYQ. And in primary health care, you need medicines as well. So we must ensure that the affordability and accessibility as highlighted by the House panel report must be ensured. That is how you can add the information from this to improve your content for this mains PYQ. For practice mains question, analyze the regulatory gap in pricing of non-scheduled drugs and suggest a policy framework for affordability. As I just mentioned, the current issue is that non-scheduled drug, the initial cost, that means the introductory prices could be anything and there is no control of any agency on it. Apart from that, they maybe keep it increasing 10% annually. For example, suppose the cost of production is just 10 rupees. Okay, just imagine. But the introductory market price could be 1000 as well. So this is the real situation. And then they keep it increasing 10% annually as well. So this is the issue. This is the profiteering that needs to be curbed as per the House panel report to ensure that the segment remains affordable to the common Indian masses. Now, another news is that PM internship scheme sees poor uptake. That means it is not well taken by the beneficiaries. There are some issues associated with it. First, the data is that the target was 1.25 lakh opportunities. However, it has increased. However, it has breached this. That means that more opportunities were provided, but people are not willing to take up on these. Now, what are the challenges? So, launched by Ministry of Corporate Affairs to provide 1 crore internship over 5 years in India's top 500 companies. It works independently of existing skill apprenticeship student training schemes. For example, Pradhan Mantri Kaushal Vikas Yojana is one, but this scheme is independent of all those schemes. Duration is 12 months. That means it's a long-term plan for 1 year apprenticeship, in which 6 months has to be in the real real work situation. Objective was again the same, that youth must get real hand exposure so that they are well prepared for the need of the industries. Pilot project was that offered 2 round combined 1.65 lakh was there and the target was 1.25 lakh. So that means opportunities are higher, but people are not willing to take. Now, what are the challenges? First is low acceptance of offer due to very far away places. That is one of the issue. The people do not want to commute to the far away places just for the apprenticeship. Second is the role mismatch. Interns are reluctant to accept role that did not match their interest or profile. Thirdly, it's a very long duration, 1 year program. And also high dropout rate. Man who joined left early due to unsuitable job roles, long commitment periods and travel constraints. Because of this, the scheme sees poor uptake. So what needs to be done? Way forward is that, first of all, offer location flexible or hybrid options. It may be work from home if possible, or otherwise please ensure that the opportunities are near the vicinity of the people. Reduce or make 12 months duration more flexible so that it will improve the uptake. align roles with the candidate's skills and interest for better acceptance, strengthen counseling and orientation to set expectations among the people also, right? Use data-driven matching to pair candidates with a suitable internship. So these are the steps that needs to be taken to ensure that scheme remains more or less efficient. Schemes, for example, MP-LEDs was asked. Similarly, this scheme could be asked in the PYQ. For that, I have a prelims question for your practice. Consider the following statements about the PM internship scheme. It aims to provide 1 crore internship over 5 years. Okay, the pilot project exceeded its target of 1.25 lakh opportunities. The scheme is limited to technical education students only. Which of them above are correct? So it would be 1 and 2 only, right? Now mains PYQ, there was a PYQ and I will tell you how again you can integrate from this small section of the news to improve your content, and it goes like, skill development programs have succeeded in increasing human resource supply to various sectors. In this context, the statement analyze the linkages between education, skill and employment. Okay, so you can add that yes, programs, they are giving more opportunities. Okay, we have seen in terms of Pradhan Mantri Kaushal Vikas Yojana also. So the number of registrations, the certificates on papers is really high, but for employment they need some real skills, which is lagging again, because you see there's a poor uptake. People, those who have joined initially have also dropped out. So we need to work on increase acceptance and the quality of the training to ensure that education, skill and employment should go hand in hand to success India as a powerhouse of economy. All right, moving to the next, we have Supreme Court to review 2025 order contradicting Assam Accord. Very interesting. You see, issued notice to the union government on a petition filed by Assam Gana Parishad challenging clause 3, subclause 1, subclause E of the Immigration and Foreign Exemption Order 2025 violating Assam Accord. Now, what is the main issue? First, clause 3, subclause 1 of the Immigration and Foreigners Exemption Order 2025 exempt persecuted minorities from Afghanistan, Bangladesh and Pakistan, that is Hindus, Sikhs, Buddhists, Parsis, Jain and Christians, from passport and visa requirement if they entered in India before 31st December 2024. They either entered without travel documents or valid documents where validity has since expired. The exemptions allows them to stay in India legally despite lacking valid passports or visa. This is the clause that was added. Now, what is the Assam Accord? So Assam Accord stated that it was designed to stop large-scale migration from Bangladesh to protect the demographic cultural identity of the Assam. Okay. It stated that identification and deportation of all the foreigners who entered Assam on or after March 1971. But Citizenship Act stated the cutoff date is December 31, 2024. And this is the main issue. So according to the Assam Gana Parishad, key arguments is that this provision has effectively shifted the legal mandated cutoff date from 1971 to 2024, violating the section 6A of the Assam Accord. Second, now there's a threat of demographic and cultural risk, such as extension undermines the objectives of the preserving Assam's demography and safeguarding Assam linguistic and culture. Okay, clause rendered accord ties, that means indirectly legalizes post 1971 illegal migration, nullifies the provision given in the Assam Accord. Also, it also challenged the section 33 of Immigration Foreigners Act 2025 and it asks the constitutional validity. It grants the center unfettered power to allow illegal immigrants to stay indefinitely in India. It is discriminatory and inconsistent with the Citizenship Act 1955 as per the Assam Gana Parishad. Right? So, these are three fundamental questions that are there. First, the sanctity of the Assam Accord as a constitutional and legislative safeguard, because it was upheld by the Supreme Court as well. Now, the question is whether executive orders can dilute statutory provisions upheld by the Supreme Court. Third, the balance between humanitarian consideration and demographic protection unique to Assam. Okay, so humanitarian consideration for the refugees is there, but also we must ensure that the action should be taken to protect the culture unique to Assam as well. So let's see how Supreme Court will come up on this. We'll discuss it in the subsequent sessions. Now for this, there's a PYQ based on the domicile and citizenship is very often in the news and it is in the exam as well. The prelims question, consider the following statements regarding the Assam Accord. The cutoff date for citizenship is March 25, 1971. This is correct statement. The 25 exemption order extended the stay of undocumented migrants to 2024. That is also correct. the accord applies only to Bangladeshi immigrants. This is not correct. So primarily it was because of the Bangladesh infiltration, but they asked for deportation of foreigners. So Bangladesh is not specifically mentioned, hence answer would be 1 and 2 only, right? Now examine the implications of 2025 exemptions order on the Assam Accord and demographic security in Assam. So what are the implications? That it may violate the provisions that was assured under the Assam Accord, and it may impact the demographic security in the Assam by settling more and more foreigners into the Assam. That is the whole issue, and we'll wait for how Supreme Court will come upon this. Okay, now next is a piece of advice that state must not prosecute citizens without reasonable prospects of conviction. What is the recent issue? So recently Supreme Court in Tuhin Kumar Vishwas versus State of Bengal cautioned the state against prosecuting citizens without a reasonable chances of conviction. Okay, what happened? There was a case is that the criminal charges of Vajiram, intimidation and wrongful restraint filed by a woman against two brothers in Bengal, where the complainant claimed that she was a tenant. However, evidence was not in favor of her. And later on, the complainant refused to give a judicial statement. FIR lacked material evidences. That means the chances of conviction was very sleek. Still, the people were prosecuted, right? So on this background, Supreme Court has given the guidelines to the states. Now, what are the judicial highlighted by the Supreme Court? First is in its impact on judicial backlog. We know the Indian judiciary is already very overburdened. There's a lot of pendency in the Supreme Court and the High Court as well as the district courts, and because of increase in unnecessary cases, the pendency would further increase and right to speedy trials will be eroded. So Supreme Court has stated, please do not go for prosecuted of the cases which are not required, where the chances of conviction is very sleek. All right. Duty of the state. Criminal prosecution is a coercive tool, so state must use it very rationally. Right. Significant of the verdict: reinforces due process of law. It emphasizes constitutional protection against arbitrary prosecution by the state. Secondly, strengthen criminal justice reform discourse. Highlights systematic issues like poor investigation, lack of filtering, backlog is there, and also guidance for police reforms. Better training, evidentiary standards and adherence to law, so that when they are filing the charge sheet, it must have a substance which is required judiciary for solving the case on a valid grounds. Improve understanding of the misuse of the criminal laws. Illustrate judicial activism is safeguarding rights of the people. Now, what are the key principles laid by the Supreme Court in this case? First is protection of the fair process. State cannot persecute citizens without the reasonable prospects of conviction. Second, role of police and courts as initial filters. For example, Supreme Court stated that during the charge sheet, state police must ensure that there are sufficient evidences. Secondly, at the charge framing stages, court must check whether the evidences given are that strong that the court must accept this case and it must go for the trials. Avoiding abuse of criminal laws in civil dispute. Supreme Court has cautioned states against using the criminal laws as a tool to go for the civil disputes solution. Okay, so that means one should not be coerced because of the threat of the criminal charges. Assessment of the charges in this case, if I tell you, so voyeurism is like requires capturing images of a woman engaged in a private act. Neither the FIR nor the evidence stated that there was a private act. Okay, so that was there. Based on that, if I tell you the PYQs, so cases related to the trials, parole is very frequently in the exam. State governments have their own prison release parole rules. On the similar lines, this is the case where you must have a practice prelims question. Assertion. The Supreme Court in Tuhin Kumar Vishwas versus State of West Bengal questioned against prosecuting individuals where there is no reasonable prospects of the conviction. So Tuhin Kumar case, you please update your notes. This is a correct statement. Right. Now reason. The court emphasized the growing judicial backlog as the key justification for discouraging such prosecution. The statement is correct, but it is not the correct reason. Because reason Supreme Court is that due process of law, not the judicial backlog. Alright, so answer would be B, that both of A are true, but reason is not the correct rationality of statement 1. Alright, now try to write the answer. Discuss the significance of Supreme Court's ruling on prosecuting citizens without reasonable conviction, prospects for criminal justice reforms. That how this decision would help in criminal justice reforms. First of all, it has given the guidelines to the state, do not abruptly use the criminal laws. Secondly, police and courts must use as the filters so that unnecessary citizens are not prosecuted. Third, it must ensure that these criminal laws must not be used as a coercive tool to go for the civil cases settlements. All right, so that is how it will help in criminal justice reforms. Now, parliament institutional health. So we know what is happening. There are a lot more stalemates in the parliament, and because of that, if I tell you that is reduced from function only 29%, Lok Sabha and Rajya Sabha has worked only for 34%, and this has raised the fresh doubt with respect to the institutional health or the efficiency of the parliament. First, what are the effects? First of all, it's declining legislative productivity because of the stalemates recently, because of the SIR, the stalemates is happening. There's a complete deadlock in the parliament, and because of this declining legislative productivity, either the parties are in the quarrel or there are walkouts, there are protests, and because of that, the functionality, the effectiveness of the houses are decreasing. Shrinking deliberation on the legislation. So bills are being passed without minimal discussions on it, and that is something very, very concerning. For example, Article 107 requires both bills to be agreed by both of the houses. And if I tell you, the bills such as regulation of online gaming bill, merchant shipping bills, they are passed within minutes. So this is the situation because of the deadlock among the parties. Now, weakening of accountability mechanism. For example, question R. A critical tool for holding the executive accountable has severely curtailed. It was only the 23% of the question hours was used in the Lok Sabha and just 6% in the Rajya Sabha was utilized. Marginalization of the parliamentary committees also. Referred the bills to the parliamentary committees for greater scrutiny is also on a reducing trend. It was 60% in the 14th and 15th Lok Sabha, but just 20% in the 16th and 17th Lok Sabha. It weakens expert scrutiny, stakeholders consultation, bipartisanship, consensus building. So these exercises are reducing the effectiveness of the debates in the houses. Also, breakdown of opposition and government dialogue. There's a lot more deadlock happening between the treasury benches and the opposition. Why opposition is raising the issues that they are not getting enough opportunity to speak their issues. However, based on the treasury benches stated that the opposition they don't want the system to work efficiently, just try to create a chaos in the houses. And also institutional imbalances and erosion of conventions. For example, the post of deputy speaker is still not there in the entire 17th Lok Sabha, and this continues in the 18th Lok Sabha as well, which violates the constitutional convention and limits institutional balance. All right. However, please understand that this has nothing to do with the regime specific. Okay, this is not that the present government is not doing all this. There's a consistent decline in the efficiency of the parliament. For example, average sittings declined from 121 days per year in 1952 to 1970 to 68 days in 2000, and 17th Lok Sabha met just for 55 days a year, minimum in the full-time Lok Sabha so far. So there's a steady decline in all these things. Now, what are the implications of declining institutional health? As I just mentioned, poor quality of legislation because bills are being passed without proper discussion and debates. Weak executive accountability, lack of decline in the time that is given to question hour. So accountability measures are getting weakened. Erosion of democratic deliberation. Parliament risk become a rubber stamp legislature, undermining the role of a forum for reasoned debate and consensus building. That is not happening. Bills are passed within minutes. When the opposition parties are on the protest, they are out, they give a walk away, and the bills are being passed. So this is the duty of both the treasury as well as the opposition, that they must ensure the efficiency of the parliament should see some uptake. Now, decline in the public trust. Frequent disruption and rushed legislation reduce citizen faith in parliament as an effective and respective institution. Okay. Now, what needs to be done? First of all, restore government opposition dialogue. We must ensure that the treasury benches and opposition should come together and resolve the issues so that the parliament should function efficiently. Protect deliberation and question hour. It is a tool where the legislature can hold executives accountable. So we must ensure that the time must be given to the question hour. Strengthen parliamentary committees. Increase parliamentary sittings to reverse the long-term decline in working days. And also uphold constitutional conventions by promptly appointing deputy speaker. Enforce rules against disruptions while safeguarding the opposition right to dissent, right? So we must ensure there are some rules to avoid the disruptions. However, the opposition's right to dissent must be respected as well. So there has to be a delicate balance. All right. With reference to the Parliament of India, consider the following statements. Prorogation of the House of the President of India does not require the advice of the Council of Ministers. You see the things of the Parliament or the parliament as a theme is very important for your exam. PYQs are very often, you will find a lot of PYQs from the parliament sector. So I have a prelims probable question for you. Consider the following statement about parliament's functioning. Referral to the bills and standing committees has slightly increased in the 17th Lok Sabha. No, it has declined, right? So this is an incorrect statement. Average sitting in the 17th Lok Sabha is higher as compared to the average time. It is also an incorrect statement because we have seen this met for the lowest number of days. Questionnaire utilization were over 50% in the monsoon session. This is also an incorrect option. So answer would be 1, 2, and 3 because they are asking for the not correct statements. Right. Now I have a mains question for you. Analyze the factors affecting parliament institutional health and suggest reforms to enhance legislative productivity. So you have to mention what are the factors. They are given it here. Factors of parliamentary institutional health and suggest the ways. The way forward we have given it over here. Read it. I hope you have understood that. Now try to write. This would be the simplest answer and it will also help you to start writing answers for your mains examination. Okay. The next is Repealing and Amending Act 2025. This is an act, okay, which has been passed, received the assent of the President. The act provides for the repeal of certain enactments and the amendments of certain other enactments. For example, there may be some old laws, there must be some enactments, some bills which have served their purposes now. So this bill is there to repeal or amend those provisions. The objective, if I tell you, is to repeal enactment that have ceased to be in force or have become obsolete, eliminate the need of retaining certain laws as separate acts, and rectify minor amendments and formal defects identified in existing legislations. So what are the key provisions of this act? It has repealed some 71 acts and 65 of these are amendment acts whose purpose have been already served. For example, Indian Tramway Act, Levi Sugar Price Equalization Fund. Okay, so amendments to the existing bills. This is important. This you must remember. The bill had amends 4 acts for technical and procedural clarity. First is General Clause Act 1897. Second is Code of Civil Procedure 1908 and Indian Succession Act 1925. The code, it removes the requirement of court's validation to wills in certain cases, simplifying the succession procedure. And also Disaster Management Act 2005 rectifies a drafting error. Government clarified that the amendment of this Disaster Management Act 2005 is the intent is to technical correction, not the duration of the safeguard. Okay, so this is significance is enhanced accessibility to the law for citizens and administrator because it has simplified the process. Support governance reform through legal simplification. All right, now let's see the prelims question. Consider the following statement about the Repealing and Amending Act 2005. It repeals 71 acts including 65 amendment acts. That is true. It diluted the Disaster Management Act 2005. No, government has explicitly mentioned that the objective is to simplify the law, not to dilute the law. The act aims to enhance accessibility to the laws of citizens by simplifying the laws. So this is the correct statement. Answer would be 1 and 3 only. Now, Nai Chetna, the scheme. So Minister of State for Rural Development has introduced a state level Nai Chetna 4.0 in Guntur. Okay, what is this Nai Chetna scheme? Under the National Rural Livelihood Mission, okay, they try to address gender-based violence and promote women's safety, dignity and empowerment in rural India. Okay, nature is that they want to make it as a people's movement. They don't want to limit it just a government initiative, and they are powered by the women self-help group and emphasize collective responsibility and community-led action so that the empowerment of the women in the rural section should take place. Objective is to achieve zero tolerance towards the gender-based violence, ensure safety, dignity and access to justice for women, strengthen women's collective leadership so that women should act as an agent of change, not just a passive receptor. Encourage participation of men and boys in changing social norms because social change always starts from the society itself. Okay. Now, this scheme links women's safety with national development, recognizing women as an empowerment cornerstone. That means women are the agent of change in India, right? So this is about the scheme. Let's see. Consider the following statement regarding Nai Chetna. It is an initiative of under Deen Dayal Upadhyay National Rural Livelihood Mission to address gender-based violence. This is correct. Okay. And it works in close coordination of the women-led SDGs. This is correct. The objective of the scheme is to strengthen women's collective and leadership. This is also correct. They are asking for which of among other not correct. So answer would be D. None of them are not correct because all of them are correct. Next scheme, we have the Sanchar Mitra scheme. Sanchar means communication, Mitra means the volunteer. So Ministry of State for Communication and Rural Development said that 222 institutions are currently participating in the Sanchar Mitra scheme. What is this scheme all about? Department of Telecommunication under Ministry of Communication, it has tried to engage with the youth volunteers to promote digital empowerment and safe telecom users among the vulnerable sections of the society. Alright, so target group are the students from technical institution which are offering telecom, electronics, computer science, cybersecurity related programs. What they will do, what are the roles? They will conduct awareness in the vulnerable sections, for example, tribal areas, to promote citizen-centric telecom services, fraud prevention and mobile security, and responsible telecom use. Because we know the cases of cyber phishing are increasing, cyber arrest are increasing in the country. Implementing agencies, Department of Telecommunication through this licensed service area field officers. And it is implemented in all states and UT. Right? Now consider the following statements about the Sanchar Mitra scheme. It engages youth from technical institution as volunteers. The focus on promoting digital awareness and safe telecom use. It was implemented by Ministry of Rural Development. No, it was Ministry of Communication. Okay, so answer would be 1 and 2 only. Now, Sujalam Bharat app. So as the name, it is very much clear that Ministry of Jal Shakti launched up Sujalam Bharat application, a digital initiative to strengthen rural drinking water governance. So what they will do, this is an application, this is a platform made by BISIC-N, which will try to put the data that from which scheme is supplying water to which part of the village and which household is getting water from which scheme, so that they can have a data-based governance when it comes to the providing water and sanitation facilities to the villages. And this is the agenda of Sujalam Bharat app. To improve transparency and accountability in rural water supply, strengthen community ownership, and enable data-driven planning, monitoring, and operations and maintenance. Alright, it will have a Sujal Gaon ID, that means unique ID for every scheme and habitation, clearly mapping which scheme supplies water to which households, so that they can remove the redundancy and also increase the efficiency of the schemes. Advanced georeferencing. This is based mapping of rural water infrastructure integrated with Pradhan Mantri Gati Shakti GIS Yojana. Governance and implementation, nationwide participation of all states and UTs, timely data integration and adaptation, and training and orientation of the people conducted by BISIC-N to ensure smooth and on-ground implementation. Right. So what is the significance? Unified digital view of every rural water scheme, enhances service reliability, water quality monitoring, and long-term sustainability of these schemes, because we know water scarcity is a real threat in India. It also acts as a digital backbone of Jal Jeevan mission. So consider the following statements regarding the Sujalam Bharat app. It is launched under the Jal Jeevan mission. It provides geo-reference data for rural water scheme developed by BISIC-N. All three are correct. Answer would be 1, 2, and 3. Now, recent development, Supreme Court's ruling on narco test has came again. Supreme Court has recently struck down the provision given by the Bihar High Court in Amlesh Kumar versus State of Bihar case, and upheld the guidelines given by the Honorable Supreme Court of India in the Selvi versus State of Karnataka case in 2010 with respect to the narco test. So what is the narco test? First of all, it is an investigative techniques where the accused is sedated with drugs such as sodium pentothal to lower inhibition and extracted concealed information. It is a non-violent method. Okay. Now, why narco tests, polygraphs, and brain mappings are problematic without a consent by the person? First of all, it is a violation of fundamental right. Article 20 subclause 3, the right against self-incrimination. Okay, and if you just force a person to go for the narco test, this right is violated. This is what Supreme Court stated in Selvi versus State of Karnataka, that involuntary narco test or polygraph or brain mapping test violates the guarantee, and any information so obtained is inadmissible in court of law. Right? Also, Article 21, personal liberty, privacy, and due process of law is not fulfilled if the person is forced to go for a narco test. It promotes mental privacy and bodily autonomy. Right? So, Supreme Court said that any narco test without strict procedural safeguard violates this constitutional framework, which is a golden trinity of Article 14, 19, and 21. Evidentiary values, what is there? Court's position is that in Manoj Kumar Saini versus State of MP 2023 case and Vinobhai versus State of Kerala 25 case, Supreme Court stated that the narco test results do not establish guilt. Okay, this is the first thing. Please understand, narco test results do not establish guilt. At max, the information obtained could be used which may assist in investigation but must be independently corroborated by the admissible evidences. Okay, so whatever information is there in the narco test, it may be used for the investigation purposes. It is not like a proof of guilt in the courts. Consent and procedural safeguard, it must be free and informed, recorded before a magistrate and accompanied by a medical, legal and procedural safeguard. Ethical and natural justice concern, if it is not fulfilling the individual autonomy, a core principle of natural justice is violated. This is all highlighted by the Supreme Court in the recent judgments. Okay, so for example, right to marry, Article 21, all these things, and the expansion of the articles are very often in the exam. So, prelims probable question, consider the following statement about the Supreme Court ruling on narco test. Forced narco test violates Article 20 subclause 3. Yes, it's against the right against self-incrimination. Okay, the rules is based on the Selvi versus State of Karnataka, and this is the case. You must remember, it would be helpful for validation in your mains examination. This is also correct. Narco test results are admissible as evidence. These are not admissible as evidence in the court of law. At max, it could be used in the investigation purposes. Right? They are asking for which of them are not correct. So answer would be 3 only. Okay, we have a mains question. Evaluate the constitutional balance struck by Supreme Court between individual liberty under Article 20 and state interest in crime detection. So they're asking that Supreme Court has stated that yes, you can go for the narco test, but it must be voluntary provision, it must be informed, and it must be backed up by the legal, medical and procedural safeguards. This would help the state interest in crime detection. So you must go, but you must respect the fundamental rights, for example, Article 20 subclause 3 and Article 21. Okay, if we go these things hand in hand, this would help in promote individual liberty also, and also it will promote the state interest in crime detection. Okay. Now, next is legal framework for revoking passports. I am sure you are aware that there was a fire in the clubhouse of the Goa, and now the Ministry of External Affairs is reviewing the Goa government's request to revoke the passport of Saurabh and Gaurav Luthra, operators of the Birch by Romeo Lane nightclub, where a fire killed 25 people recently. But what is important for your exam is that legal framework for revoking passport. Okay, this is something very technical. There is no arbitrary actions can be taken by the government. Let me tell you, the issuance, impounding and revocation of the passport in India are governed by Passports Act 1967. Please do not get confused with the Citizenship Amendment Act or Citizenship Act 1955. Primarily Section 10 subclause 3. The power is not absolute and cannot be exercised arbitrarily. This is important. The passport may be revoked only on the specified legal ground, and that is why Ministry of External Affairs is reviewing the request appraised by the Goa government. The first is, the ground is that first there must be a pending criminal proceedings before an Indian court. This could be one of the ground, or it must have a issuance of summons, warrant or arrest warrant by a court, action taken in the interest of general public, or where the holder's conduct is prejudicial to India's sovereignty, integrity or security, suppression or misinterpretation of the material facts, and the court order restraining the individual to leaving from India. If any of these grounds are there, these are the legal grounds on which the passport could be revoked. Okay, generally it is regulated and legally constrained measure. Why? Because Supreme Court in Menka Gandhi case stated that the right to travel abroad is a fundamental right, and revocation of passport without the legal safeguards might erode this fundamental rights and will come under the judicial scrutiny. Okay, so due process and right to be heard. Since passport revocation affects a fundamental right, Section 10(5) of Passport Act, authority must record reason in written and communicate to the passport holder that why her or his passport has been revoked. Now, judicial checks on state powers. If I tell you the previous case laws, so mandatory natural justice. Court requires a show cause notice, fair hearing and reasoned speaking order before passport is revoked. Evidence must be based on the evidence, not just mere allegations. Okay, distinguishing misconduct from a mistake, that there must not be a bona fide mistake, it must have to be a planned mistake, which are the ground for the revocation of the passport. Now, what are the consequences if the passports is revoked? First is loss of valid travel document. Second is deportation if they are in abroad, and criminal liability for misuse. If the person is using a revoked passport, it will invite a criminal liability. So based on that, you just try to solve this prelims question. Consider the following statements about passport revocation. It is governed by the Passport Act 1967. Revocation is possible for pending criminal proceedings only, right? Under Article 19, the right to travel abroad is a fundamental right as recognized in the Menka Gandhi case. They're asking for the correct statement. So we know it is Article 21, not Article 20. This is an incorrect statement. And it is not for only criminal proceedings. These are the grounds which are there. So answer is 1 only. Okay. Now, we have the Sampan is the next article that we'll be discussing. More than 1 lakh pensioner currently being serviced by the Principal Controller of Communication Accounts or Controller of Communication Accounts Office all over India by Sampan. So what is Sampan? Launched in 2018, Sampan is an online pension processing for payment system of Department of Telecommunication, DOT, pensioners only. It is implemented by the CGCA and the Department of Telecom under the Ministry of Communications. What are the objectives? Objectives is a timely settlement of the pension cases, to provide a single window, transparent and efficient pension system and direct credit to the pensioner. The key feature is e-pension system, SMS alert and faster reconciliation, auditing and accounting of the issues. Improve service delivery, reduce administrative delay and flexible and scalable system to meet future pension management needs. For example, if further we can be using, this is limited to only Department of Telecommunication employees, but this could be enlarged to improve the pension delivery system in India. Right, so consider the following statement about Sampan. It is an online processing system for DOT pensioner. It enables e-pension system. It is implemented by CGCA. So all 3 are correct. Answer would be 1, 2 and 3. Now, Bureau of Port Security. Okay, so Ministry of Home Affairs convened a meeting for constitution of a dedicated body for Bureau of Port Security for the security vessel of port facilities. Abhi tak it was under the CISF, but now they're trying to make Bureau of Port Security. Earlier, Central Industrial Security CISF, its role was designated to recognize security organization for ports. It must conduct security assessment of the ports, preparing port security plan, training and capacity building of private security agencies, and to ensure only licensed private security agencies are operating in the port security areas. Okay, now what is Bureau of Port Security? Is a statutory body. This is important, you please remember. Under Merchant Shipping Act 2025, Bureau of Port Security is a statutory body, right? It will function under the Ministry of Port, Shipping and Waterways, headed by the Director General of the same. During the 1-year transition period, Director General of the Shipping will act as a DGP for the Bureau of Port Security, right? Based on that, try to solve this prelims question. It is an executive body formed under the Ministry of Home Affairs for port securities. No, it's an statutory body. It is modeled on the Bureau of Civil Aviation Security, right? So this is a correct statement. Answer would be 2 only. The next is Center revises guidelines to help poor prisoners unable to pay fines. What is happening? Center has some guidelines so that the prisoners or under trials who are just not getting the bail or they are not getting released despite after getting the bail because they fail to fulfill the bond amount asked by the court. So if for the vulnerable section, Center has revised guidelines to help poor prisoners, those who are unable to pay fines. Okay, there's an annual fund by the union government is rupees 20 crore to help these things. Now, what is a support to poor prisoners scheme? In 2023, Ministry of Home Affairs aimed to provide financial assistance to the poor under trials and convicted prisoners which release is delayed solely due to their inability to pay the bail or court imposed fines because of the economic hardship. Okay, now objective of the scheme is like prevent prolonged incarceration caused solely by poverty rather than criminal culpability. Also to reduce prison overcrowding and alleviate hardship faced by the poor prisoners. So they were the 2 objectives. Institutional mechanism was that district level empowered committee which will comprise multiple officers. District level empowered committee will examine individual cases, assess the requirement of financial assistance for bail and authorizes release of funds into the transparent manner. So who will be responsible? It is a district level empowerment committee. Second, under trial prisoners, if not released within 7 days of a bail order, jail authorities must inform the district legal service authorities DLSA. After verification of the financial incapacity, assistance up to 40,000 per case for under trial may be provided to secure bail. Alright. In case of a convicted person, if the reason is delayed due to non-payment of fine, the jail superintendent must inform the DLSA within 7 days again, and the assistance is up to 25,000. For that under trial, it is 40,000. For a convicted person, it is 25,000. Okay. How is the funding mechanism? It's a subsidiary account under the CNA. Okay, NCRB के under है वो body. And a nodal officer of the state or the prison headquarter draws funds from the CNA based recommendation on the empowered or oversight committees and release them to the concerned prison account. So it would be a completely transparent order. A state level oversight body committee would be there to monitor implementation and approve higher amounts when necessary. Okay, so that means on the case to case basis, the amount, if required higher, could be provided as well. Now, exclusion. There are certain exclusions. For example, scheme does not apply to prisoners accused of offences under the Prevention of Corruption Act, PMLA, NDS Act, UAP, and other notified heinous offences such as terrorism, rape, trafficking, dowry, death, and POCSO offences. Now, what are the rationale of the revisions? Poor and uneven implementation of the scheme since the issuance of original guidelines in 2023, lack of clear timelines, and weak institutional ownership, resulting in delays and dilution of scheme's objectives. So now the government has came up with this new set of guidelines in this scheme. Okay, now prelims question. Consider the following statement about the support to poor prisoner scheme. It provides financial assessment to bails and fines. It excludes offences under POCSO and UAPA. The announced fund is 20. The annual fund is 20 crore. Both of them, all of them are correct. Answer would be 1, 2, and 3. Now, our mains PYQ. The construction of India is the Constitution of India. This is Constitution. The Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for progressive society, illustrated with reference special to the expanding horizon of right to life and personal liberty. Now, this is also a expanding horizon of right to life and personal liberty. So that means you can also use this scheme as one of the further point, right? Now, mains analyze the role of state-sponsored legal and financial assistance schemes in realizing substantive access to justice under Article 21. So you have to analyze the role of state-sponsored legal and financial assistance scheme. So in case of under trial, 40,000. In case of convicted person, it is 25,000. And also, if required, this state level oversight committee will monitor, and higher amounts if necessary would be given as well, so that first of all the person should walk free, because they are right, they have got the bail, and apart from that it must also reduce the overcrowding in the prisoners, right? Now, the Constitution of India released in Santhali language. This is one fact that you must remember. So President of India released the Constitution of India in the Santhali language. Okay, now important is about the Santhali language. So language family, it belongs to the Austroasiatic Munda branch of language family, distinct from Indo-Aryan, Hindi, Bengali, and Dravidian language, that of Tamil and Telugu. Okay, speakers spoken mainly in the Santhal tribal community in Jharkhand, Odisha, and West Bengal and Bihar. The script written in OI Chiki script, developed by Pandit Raghunath Murmu. And constitutional status, we know the 8th schedule of Indian Constitution by the 92nd Constitutional Amendment Act. This has the constitutional status as well. Okay, so let's have the PYQ. You see the languages, scheduled languages are in the news. It was in the exam as well. So prelims probable question. Consider the following statements about Santhali language. It includes in the 8th schedule, it uses the OI Chiki script. It is an Indo-Aryan language. It is not an Indo-Aryan languages. They are asking for the not correct statement. Answer would be 3 only. Okay, now we'll be discussing with One Nation, One License and One Payment scheme. What is this all about? Department of Promotion of Industries and Internal Trade led committees has given up a working paper where they try to balance AI innovation and copyright. So invited public feedback on that. And what is the background? DPIIT led committee has stated this is to address the growing legal uncertainty around the use of copyrighted work for training of commercial AI generative systems. Okay, so this is the issue. For that they have come. So what is the issue? There is a ingestion of human created content for commercial AI system, which risks first of all undermining copyright as an economic incentive for the creators. All right, for example, you have created some I would say some content which you have the copyright, but somebody is using it without giving you any sort of credit for their training of their AI model. So there will be lack of incentive. Second, weakening of India's creative economy. If, for example, including news, music, on audiovisual works, and also creating legal uncertainty for AI developers due to pending and fragmented litigation. For example, I may have trained my AI based on some content, and I don't know, in future somebody may come up with a copyright issue and all those things. So these were the issues on which the committee has given some recommendation. What are the recommendation? First of all, become the first jurisdiction with a statutory government administrative AI training license, provide legal certainty to the AI developers, and also protect small creators and unorganized cultural sector. Okay, prevent concentration of royalties among a few large players. Okay, so what they are tried? The committee sought a systematic, predictable, and scalable framework that balances innovation with creator protection rather than relying on piecemeal litigation or private contracts. So, for example, what is the situation now? Now, the copyright materials could be used for AI training. However, they must give some sort of credit or investment or the royalties. Okay, so with this, both of the stakeholders would be on the same page. This is the recommendation. So what is the recommendation? First, rejections of existing modes. For example, rejects voluntary licensing in text and data mining exceptions. Secondly, adopt a hybrid statutory framework. Scope of the blanket license applies to all lawfully accessed copyright works used for commercial AI training without overriding paywalls. Alright, control royalty collection mechanism. It would be collected by umbrella body, copyrights, royalties collection of AI training. Secondly, royalties rates are setting that would be done by an expert committee. Retrospective royalties would also be there. For example, the developers who has already trained their commercial AI systems, they have to pay retrospective royalties. It must be transparency and distribution, and also the enforcement mechanism. In disputes, court will presume the creator's claim to be valid, and it is the burden of the proof would be on the AI developers. All right, so this is all about the one nation, one license and one payment system. Now we have a prelims question for you. Consider the following statements about the one nation, one license, one payment framework. It proposed for AI training using copyrighted work. It includes mandatory blanket licensing. It is administered by the DPIIT. And I know that all of the three statements are correct. Answer would be 1, 2 and 3. Evaluate the proposed one nation, one license, one payment framework for balancing AI innovations and copyright protection. So you have to tell what are the recommendations given by the committee. So recommendations recommend mandatory blanket ban under which AI companies would require to pay royalties to creators for using copyrighted works in AI training. It's a blanket regulation. That means every time you are using some copyright material for training your commercial AI, you have to pay the royalties. All right, so that is how they are trying to balance the copyright protection and also promoting AI innovation in the country. Right, the next is the Sahyog portal. So what is happening? Over 2,300 orders were issued by the 19 online platforms by the Ministry of Home Affairs through the Sahyog portal. So what is the Sahyog portal? First of all, it is a centralized digital platform launched in 2024 by Ministry of Home Affairs to expedite the issuance of content blocking notices to the intermediaries, to the telecommunication providers, and also to the social media. Okay, and it is maintained by the Indian Cyber Crime Coordination Center, I4C. Right, what is the objective? Objective is to automate notices to the removal or disabling unlawful and online content. Right, to enable enforcement of intermediary due diligence obligations under the IT Act, and also support the court-directed the executive blocking orders. How it works? First of all, flagging. Authorized agencies such as center, state, police, LEAs, they flag objectionable content. Notices issues directly to the information technology intermediaries, and also action and reporting. They have to update the status within the given time frame. Key features is a single window platform, authorizes agencies, intermediaries, and ISPs, so that faster coordinated responses to the online violations. Right, so this is there. Now what is the significance? Faster enforcement, as I just mentioned, against cyber frauds and organized crimes. Centralized coordinated mechanism. It brings together authorized government agencies, information technologies, and internet service providers. Operationalization of Section 79, Clause 3, Subclause B of IT Act, enhanced national cybersecurity framework. It supports proactive disruption of criminal networks through large-scale blocking of fraudulent accounts, contributing to safer cyberspace. And also, this process is judicially endorsed. However, there are some concerns. First, risk of over-blocking and censorship. Okay, civil societies and platform argue that expedite blocking without robust safeguard may suppress lawful speech and dissent. Limited transparencies, orders and reason for blocking are not always in the public domain. Due process and natural justice. Absence of prior notice to hearing of affected user. Maybe there is my content, but the content has been put down and I have no hearing in that. Right, so that is a violation of due process and natural justice and executive overreach. Heavy reliance on the executive discretion under Section 79, Clause 3, Subclause B rather than judicial oversight. Okay, compliance burden on intermediaries. Smaller platforms may face technical and resource glitches in responding to frequent and time-bound implications of these notices. So this is all about the Sahyog portal. Consider the following statement regarding the Sahyog portal. It is launched by the Home Ministry. Used for blocking cyber fraud content. It uses the IT Act 2000 for its enforcement. So it is taking the power from this legislation, which is known as Information Technology Act 2000 for its enforcement? Answer would be 1, 2 and 3. Right. Now means assess the interplay between portals like Sahyog and Sanchar Sathi. We discussed in the very first article in addressing cyber frauds through content takedown and citizenship reporting mechanism. That is how you should keep interacting with the things that you have read. Okay, so that is how you should try to integrate your current affairs, different sections. So cyber frauds, we have read two things. One is Sanchar Sathi and second is Sahyog portal. Okay, so this is the question all about. You have to write what are the provisions, how Sanchar Sathi would help in tackling the cyber frauds and how Sahyog Sathi will help in tackling the cyber frauds. Okay. Now, new safeguards to protect great Indian bustard from power lines. So recently, Supreme Court, after like 6 years of this court case, has ordered to conserve the critically endangered great Indian bustard. The first thing you should remember that the IUCN status is critically endangered for great Indian bustard, and their location is mostly in the Rajasthan and Gujarat. So this is the two questions that could be asked in the prelims. You must be prepared for it. Now, what is the great Indian bustard about? If I tell you the status of range, it is like fewer than 150 birds are left. It is mostly in the Rajasthan and a few in the Gujarat area. The population has significantly declined, and it is nearly 95% of the population is in Rajasthan, and hardly 3 females are there in Gujarat. What are the key threats? First is habitat loss, the grassland loss. Second is fatal collision with the electrolocation from high voltage power lines linked to the wind and solar projects in Rajasthan and Gujarat. Reproductive challenge is that the species has very low reproductive rate, that is 1 egg per season, which makes it very difficult to recovery. Alright, now the case background is that it was started in 2019 with the PIL filed in the court that the collision with overhead power transmission lines from solar and wind project emerged as a major cause of mortality among the great Indian bustard. Scientific basis that Wildlife Institute of India in 2018 warned that without immediate mitigation of power line collision, GIB extinction is inevitable, and based on that, because they have a very high body, okay, so that is why the frontal vision is also very poor and they have a very heavy body, so they cannot immediately change the track, and because of that they just get into this accident. All right, interim judicial orders were there in 2021. Supreme Court stated that new overhead transmission over 99,000 square kilometer directed undergrounding of power lines and mandated bird flight diverters. Two things, first underlining of the cables, and second is the bird flight diverters आपको वहां लगाने थे. But there were some challenges. Union in a ministry stated that first of all the technical infeasible, this is underground cables, and second high cost and conflict with India's renewable energy and climate goals. Alright, on this 2024 Supreme Court modified the blanket ban and noting that underground alone would not save, it considered an expert committee to balance biodiversity conservation as well as climate change mitigation, because both of them are important, right? Now the final verdict has come, and it stated that first, revised priority areas, it has increased from 13,163 kilometers in Gujarat to 14,013 kilometers, and in Rajasthan and in Gujarat it is from 500 to 740 kilometers. So in Rajasthan it is up to 14,013 kilometers, and in Gujarat it is increased up to 740 square kilometers. Now these priority areas are the core breeding ground and high use habitats. Okay. Second is creation of dedicated power line corridors. Supreme Court had stated that the dedicated power line corridors to reroute overhead transmission lines away from the critical GIB habitat. Alright. Now restrictions on the renewable energy project. First of all, no new overhead cable except 11 kV or below. Second, no new wind turbines in this priority areas. Third, no new solar parks plants above 2 megawatt. No expansion of existing solar park. It marked a clear ecological red line for infrastructure development in the high priority area. Right? Voltage based power mitigation. For example, the court has updated a graded voltage based approach in Rajasthan. Immediate underground of 80 kilometers of 33 kilowatt lines. Remaining lines to be undergrounded, rerouted or insulated. All works to be completed before 2028. Right? So graded approach hai. If that is like more than 33 kV in Gujarat, in Rajasthan up to 80 kilometers, they have to be underlined. For other, they either you have to reroute it or they have to insulate it. Right? In Gujarat, undergrounding of 79.2 kilometers of 33 kV and 69.4 kilometers of 66 kV lines. 250 kilometers of critical lines identified by Wildlife Institute of India to be underground within 2 years. Okay, 11 kV and below, they were allowed preferably with the insulated cables. So this is how they have gone for a graded approach rather than a blanket ban. Bird flight diverters, so the court did not mandated its universal installation, because this is that the scientific assessment becomes for that is a future is required. For example, the bird flight diverter is not mandated by the Supreme Court because it has accepted that effectiveness is not conclusive established. Okay. Now, conservation measures beyond power lines in Gujarat or Rajasthan, the better is that first is that you should go for the habitat restoration, predator management, enclosure improvement, and food and water management. Community participation is very, very important, and continuation of the project GIB. Okay, and in Gujarat, because there are only 3 females are left, so we will be adoption of jumpstart conservation, where translocation of fertile egg from Rajasthan to Gujarat and incubation by the wild females. All right, what is the implication of the verdict? First of all, ecological significance, strongest judicial protection yet to India's grassland ecosystem by moving conservation from species-centric to landscape-level planning. Now, we will not be just saving the species, we will try to save the landscape, and if the habitat is secured, the species recovery chance will increase. Okay, and also it has given the ways to renewable energy governance and ends regulatory uncertainty created in 2021 blanket ban. Okay, also constitutional balance, explicitly balanced Article 21, right to life, including ecological health, and also environmental protection duties under Article 48A. Right, and India's climate change and renewable goals, thus clarifying the climate action cannot come at the cost of irreversible biodiversity loss. Okay, so precedental values, science-based adjudication, use of expert committee in complex techno-ecological conflicts, and harmonizing development, conservation, and climate goals. So Supreme Court in this judgment has tried to promote all these things. Okay, so let's see. Ecologically sensitive questions are very much in the news, and I have a prelims proposal for you. Consider the following statements about the Great Indian Bustard. It is critically endangered by IUCN. The Supreme Court mandated bird flight diverters for all power lines. This is an incorrect statement because it is not valid. What is their efficiency? Okay, priority conservation areas were revised in 2025. Yes, it has expanded. Okay, so they are asking for the not correct statement. Answer would be 2 only. Now, I have a mains question. Discuss the application of sustainable development in balancing species and habitat protection with the imperative of renewable energy development with reference to recent Supreme Court judgment. Right? Supreme Court has tried to uphold development, conservation, and climate goal, and this is what you have to write in this answer. I hope you will be able to write. We just discussed. Now, draft content syndication policy 2025. Right? Prasar Bharati, a government-owned national broadcaster, recently uploaded a draft content syndication policy on its website for public consultation. Okay, now the key features of the policy, if I tell you, is a wide content coverage, right? Doordarshan and Akashvani, they have like archived national and regional programs, live coverage of government events. Now they just want to have a syndication policy for that. Multiple syndication models are there. First, public non-commercial syndication for education and awareness. Commercial syndication for broadcasters, OTTs and IPTV platforms. International syndication as well. Flexible monetization and licensing. The policy adopts flexible market-aligned monetization. Flat fee licensing for one-time content use. Revenue sharing agreements based on actual earnings and minimum guarantee with revenue share. So this is the provision in that. Now, what are the objectives of this syndicate policy? Is that monetization of public broadcasting content to ensure financial sustainability. First thing. Promotional of outreach, cultural outreach, right? Expansion of access to Prasar Bharati's vast archival and live content. Strategic collaboration with domestic and global platforms. Balancing commercial use with public interest, right? And also strengthening India's global cultural presence through its soft power diplomacy. Now, what is the significance of the policy? Economic value realization. First of all, Prasar Bharati needs funds for sustainability. Second, digital and market integration. It integrates public broadcasting with OTT and wider digital ecosystem, aligns Prasar Bharati with contemporary market-oriented media practices. Otherwise, it will be obsolete. Alright, soft power and cultural outreach, institutional transform. It positions Prasar Bharati as a content provided, not merely a broadcaster, and reflects a shift from modern market-aligned public media governance model. Right? Public interest balance is there. Now, I have a prelims question for you. Regarding the draft syndication policy, it is proposed by Prasar Bharati. It covers only TV content. It promotes commercial syndication. So, TV content is not there. They are promoting for OTT as well. Answer would be 1 in 3 only. Right? Now, very important for your exam is Pesa Mahotsav. Ministry of Panchayati Raj is celebrating a 2-day Pesa Mahotsav Utsav Lok Sanskriti Ka in Visakhapatnam, Andhra Pradesh. Okay, which marks the anniversary of the Panchayati Raj extension to Schedule Areas Act 1996. What is the PESA Act? So, this is to extend the provision of 73rd Constitution Amendment to the Scheduled Areas in the 5th Schedule of the Indian Constitution. It provides a legal framework for self-governance in tribal areas by empowering Gram Sabha and Panchayats. Okay. Important for your mains and prelims examination are the objectives of the PESA Act. First, primacy of the Gram Sabha. Understand that the Gram Sabha is empowered to approve development plans, programs and projects, identify beneficiaries for the government schemes, and protect custom, tradition, and social cultural identity and community resources. Okay. Second, consonance with the customary law. State law must be in conformity with the tribal customary practices. This is important that the Gram Sabha will have control over natural resources, ownership of minor forest produce, planning and management of minor water bodies. Consultation is mandatory. This is important. Please try to understand. Consultation is important for land acquisition, rehab and resettlement, mining leases for minerals, that is minor minerals. Consultation is mandatory. It is not binding. This is the catch that UPSC often checks. Socio-economic regulation, power to regulate village markets, money lending, sales and consumption of intoxicants, and it is an authority to prevent alienation of tribal land and restore unlawfully alienated land. Okay. Political representation. So proportional reservations for the STs. In Panchayat, chairperson positions are reserved for the STs, and the provision of nomination of ST members if they are not adequately represented. Okay. Now, what are the objectives of this PESA Act? If I tell you, the first of all, the Panchayat Raj provisions to the 5th schedule areas. We know 8.6% of the Indian population is a tribal. Apart from the Article 244 of the Indian Constitution is schedule areas by the President under Article 244 as well. At present, 10 states have 5th schedule areas and the 4 states have the 6th schedule areas. Now, to restore and protect the rights of tribals communities over their land and water, forest as well. Right. What is the need for PESA Act? The 73 Amendment Act did not automatically apply to the schedule areas. This is something you should remember. Okay. Because they already have some community-driven custom. They also have their own committees on sabhas and samitis. So for that, it is expanded explicitly. All right. So that is there. Now let's see government initiatives. First is PESA Mahotsav. We just discussed. Apart from that, there's a capacity building program. Over 1 lakh elected representatives trained across schedule areas. State and district level master training program is also run by the government. And also you have PESA Gram Panchayat Development Plan Portal, enables hamlet wise, village wise planning aligned with tribals priorities and facilitates effective utilization of finance commission grants and schemes funds. Okay. Also institutional support, creation of a dedicated PESA cell in Ministry of Panchayati Raj for translation PESA manuals into regional and tribals language to improve the accessibility. Now, Center of Excellence on PESA established in central universities to institutionalize training, documentation and research. Okay. Now, what are the significance of this PESA Act? Strengthening grassroots democracy, community control over natural resources, protection against displacement and alienation of the tribal people, promotion of sustainable and cultural sensitive development, enhanced accountability through Gram Sabhas, and advancing constitutional decentralization and social justice for tribal communities. However, there are some challenges. First is incomplete rule framing. Some states have left draft PESA rules or weak implementation. Administrative resistance to reluctance of line departments to cede powers to the Gram Sabhas. Low awareness among the people themselves and conflict with sectoral laws. Overlaps with the Forest Acts, Mining Acts, Wildlife laws which dilute the power of the Gram Sabha. Capacity constraints. Okay. So you have the constraint funds, function and functionaries. That is there, and also the tokenism. Gram Sabha consultations often reduced to just procedural formalities. As I just mentioned, it is not binding, just the procedures. Okay, so on that I have a PY. We have seen a PESA PYQ and also we have a prelims question for you. Consider the following statements about the PESA Act 1996. It empowers Gram Sabha in scheduled areas. It applies to all states with a tribal population. Okay, it regulates minor forest produce ownership. Okay, so we know this is not correct. Okay, because 6th schedule also there. So it is in the 10 states only. Answer would be 1 and 3 only. Right. Now mains PYQ, if I tell you, the strength and sustenance of local institutions in India has shifted from their formative phase of functions, functionaries and funds to the contemporary stage of functionality. Highlight the critical challenges faced by the local institutions in terms of their functionality in recent time. So these are the challenges that you can use in this PYQ also. Right. So these are the challenges in their functionalities. First of all, incomplete rule framing, administrative resistance, low awareness, conflict with sectoral law and capacity constraint and lack of awareness. Right? Try to write this answer. Analyze the key obstacles in the implementation of the PESA Act to discuss the steps taken by the government to strengthen grassroots governance in scheduled areas. Right? The obstacles are the challenges and the government steps is PESA Mahotsav. You have Schedule 5 and Schedule 6. Alright, and then we have capacity building program. And also we have GP, GD portal, and also Pesa cell. So these points you should remember, take a note of this, otherwise it would be difficult. Okay, then what will you will not be able to remember more points to write these very basic answers in the exam. Okay. Now next, Delhi High Court can test constitutional validity of the Special Marriage Act provision. What has happened? Recently, the Supreme Court has struck down the request of Ministry of Law to transfer the case from Delhi High Court to the Supreme Court with respect to the Special Marriage Act provisions. Alright, now there's a case related to constitutional validity of the Section 6 and Section 7 of Special Marriage Act. What is the Section 6 and Section 7? Section 6 requires the issuance of public notice inviting objections for the intended marriage. Okay, a Special Marriage Act is basically a secular law, applies to all the citizens of India irrespective of their religion and caste, and this is the Section 6. If you want to register your marriage under Special Marriage Act under Section 6, there's a public notice inviting objection to the intended marriage, and Section 7 outlines the process of how marriage officers will handle those objections, including conducting inquiries and potentially refusing to solemnize the marriage if the objections are found to be valid under the law. Okay, so this is the Sections 6 and 7 which would be now under the lens of constitutional validity. Alright, what is Special Marriage Act 1954? For secular marriage, for the marriage where the state, not religion, sanctions the marriage, India recognizes both religious marriage as well as civil marriage under Special Marriage Act. Okay, now rationale and significance is that in the existing personal laws, in case you want to go for an inter-religious marriage, it needs to be the religious conversion. To avoid that phenomena, the provision is there in the Special Marriage Act that if the people are from inter-religion, they can get married within the Special Marriage Act without getting converted to another religion. Okay. Applicability and eligibility, it is for all religion. Minimum age, like male 21, female 18 years. Like Section 19 is that person belonging to undivided Hindu, Buddhist, Sikh or Jain family, and if he marries to someone under Special Marriage Act, then that person deemed to be separated from the joint family, and this may affect inheritance and property rights. This is also one of the challenge in this act. Right, notice period and objections. For example, Section 6, as I just mentioned, it will invite objections within 30 days and anyone can issue an object. This is one of the challenge. Okay, and critics is that invading privacy for if the people, the two adults, they want to marriage, and if they have to give prior notice for their marriage, that will invite the social objections. This erode their right of privacy. Right, enabling harassment, social pressure and familial interference, because now they have to, first of all, for 30 days they have to give a public notice that they are intended to marriage. This is one of the challenge. Endangering couples, particularly by interfaith or intercaste marriages. Disclosure of personal matrimonial intent may jeopardize the life and liberty. So these are some challenges that have been raised in this case, and now the constitutional validity of Section 6 and Section 7 of the Special Marriage Act would be tested. So you see, these sort of questions, for example, right to marry the person of one choice was asked in the UPSC. For that, I have a prelims question for you. Special Marriage Act 1954, it requires a 30-day public notice for marriages. It applies only to interfaith marriages. No, it is not only, it is open for everyone. It's a secular framework for civil marriages. This is also correct. They are asking for the not correct, so answer would be 2 only. Okay, now try to write down this answer. Analyze the constitutional challenges to the notice provision for the Special Marriage Act 1954 in light of Article 21 of the Constitution and the evolving interpretation of right to marry. Okay, so we know in the Hadia case, Supreme Court has given right to marry of your choice as one of the fundamental right under Article 21, and apart from that, Article 21 also protect right to privacy. So these two articles are maybe violated, and now we'll be waiting for the judgment of the honorable courts. Now, next is Supreme Court states former Maharashtra Agriculture Minister's conviction. There's a difference between the two. Supreme Court recently stated the conviction of a minister in document tampering case related to illegal allotment of government flat. But this is more important. You should know the difference between suspension of sentence versus stay of conviction. Okay. Suspension of sentence means the punishment is paused. That means the person may not be jailed, but convict status continues, so legal consequences may be followed. Okay, this is the suspension of sentence. Stay of conviction is that the convict status itself is put on hold. Collateral consequences like disqualification from office would not follow. This is the difference between the two. Why Supreme Court relief is crucial? Because under the Representation of People Act, if a person is convicted for 2 years or more, that person is disqualified. Okay, So that is why when the Bombay High Court just given the suspension from sentence, it was not a crucial relief. Okay. Now Supreme Court's legal reasoning on stay of conviction. Supreme Court stated that it will prevent immediate disqualification of elected representative, reaffirms the distinction between punishment and convict status. All right. So this could be asked in your exam. RPA very much in the news and sometimes it is in the exams as well. Prelims question. Consider the following statement about stay of conviction. It prevents disqualification from public office. It is granted only if serious prejudice is shown. Right? It is the same as suspension of the sentence. No, it is not same as the suspension of the sentence, because in the suspension of the sentence, you may not be jailed, but the convictions may follow. Okay, that is why answer would be 1 and 2 only. Now, on what ground a people's representative can be disqualified under the Representation of People Act 1951? Also mention the remedies available to such person against his disqualification. Right? So you have to mention what are the grounds. If the person is convicted for 2 years or more under the 1951 RP Act, he or she could be disqualified. Okay, remedies is that the person can seek the stay of conviction from the courts. Now, important and a very good approach is that Karnataka Social Boycott Prevention Prohibition Redressal Bill 2025. What is this bill all about? This Karnataka government has tries to criminalize social boycott imposed on individuals or group by caste or community bodies, right? Including informal caste panchayats, by treating social boycott as a violation of fundamental rights and human dignity under Article 21. Right? Objective of the bill is to eradicate the unconstitutional practice of social boycott and protect individual dignity. Provision. It has a wide definition of social boycott. Almost everything. For example, it is oral, written or physical act of social discrimination imposed by caste, panchayat, group or any person who ostracized or excluded through denial of social, religious, economic, educational, profession or public interaction is access, such as marriage, resulting in isolation and hardship. Such boycott is prohibited and constitute an offense. So almost everything has put into the definition part. Criminal offense and penalties of social boycott. Okay. So it will constitute a criminal offense punishable with imprisonment up to 3 years and fine up to 1 lakh or both. Liability of caste panchayats. Okay. If the person influences the caste panchayat decision, even if the person is absent, or the members who vote or participate in such deliberation and organizers or the participants of unlawful assemblies convene to impose a boycott, they will be liable for these things. Okay, invalidation of pre-existing social boycotts, compounding of offense. The offense act may be compounded. That means there may be a compromise with the victim's consent and the court's permission, subject that the accused perform court-directed community services. This is one thing that you should remember. Cognizable and bailable offense. An offense punishable under the act shall be cognizable. That means a prior permission from the court is not required for filing the FIR and arrest the person, but it is also bailable in nature, trialable by the judicial magistrate of the first class. Okay, so bail ho sakta hai, it is compoundable also, and it is cognizable also. Right? Victim-centric measure is that the court must hear the victim on the quantum of sentence and then only pass the sentence. Right? Second, preventive power of deputy commissioner. If receiving the information, the deputy commissioner may prohibit such assembly or related act in specified areas and issue necessary directions to the police to enforce the orders. Social boycott prohibition offers more like the Dhamma Mahamatras of Ashoka. They may appoint a group A officers of the social boycott prohibition officers for specified areas. Non-derogation and application of BNS 2023. So it will operate in sync with the Bharatiya Nyaya Samhita 2023 if the acts disclose such offences. However, there are some concerns. First, narrow community definition. It only limits to intra-community boycott, not the inter-community boycott. All right. So, for example, limited to intra-community religious caste discrimination, leaving exclusion by external groups unaddressed. Right. Proof address informal or silent boycotts. It would be very difficult to prove these things. Weak stance on caste panchayat, not explicitly banned despite judicial criticism. Compoundable offense, risk of coerced settlement for victims may undermine deterrence. Enforcement doubts, experience under Maharashtra's 2016 law shows few trials and convictions. And implementation gap, although the offense is cognizable, but ground level effectiveness remain uncertain. Okay, so on this background, just try to solve this question. Consider the following statement about the Karnataka Social Boycott Bill 2025. It criminalizes social boycotts by caste panchayats. Offences are cognizable and non-bailable. No, it is cognizable, but it is bailable as well. It allows compounding of offences with court permission. This is also correct statement. So answer would be 1 and 3 only. right? Now, the Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for progressive society, illustrated with special reference to expanding horizon of right to life and personal liberty, right? So, this is right against social boycott is also increasing the expansion of right to life and personal liberty. You can always use this as an example for validation in your exam. Now, mains, if I tell you, analyze how the Karnataka Social Boycott Bill 25 seeks to address caste-based social exclusion and access its constitutional alignment with Article 14 and 21. So you have to mention how it will promote right to equality and right to dignified life and personal liberty. Okay. Now, center plans to make a portal to provide all forest rights online, single window system, so that it will promote good governance. The named as Tarang, which is a beta version, aimed to taking the entire process of recognition and management under the Forest Right Act 2006 as online, right? Key features is that end-to-end digital process for FRA claims, issuance of digital title deeds and digitalization of legacy, GPS and satellite-based land making and geotagging, creation of FRA atlas, so that there is not a alienation of land unlawful, right? Future roadmap, use of AI-based optical character recognition for digitization records, in sync with the Swamitva village survey scheme and satellite and drone-based analysis, possible linkage with Article 275 Clause 1 for special grant for ST welfares. Okay, what do you have to prelims is, Tarang recently seen in the news is related to, it's a national web portal being developed as a single window digital system for implementation of the Forest Right Act 2006. All right. Now, passenger assistant control rooms, we have just discussed the Indigo meltdown. After that, to enable faster redressal of air passengers' grievance, Ministry of Civil Aviation has recently established 24/7 passenger assistance control room. It will have an integrated operations, okay, bringing together officials from Ministry of Civil Aviation, Director General of Civil Aviation, Airport Authority of India, airline operators, and other stakeholders. 24/7 functioning hai. Technology backbone hai, fully integrates with the Air Seva system, enables travelers to submit grievance and seek information on air travel in India. On-spot resolution and priority coverage focus on delays, cancellation, refunds, and baggage issues, right? So consider the following statement about the passenger assistant control room. Operates 24/7 at Udan Bhavan. It integrates the Air Seva system. It focuses only on delay and cancellation. It focuses on baggage issues, refunds, cancellation, and delays as well, right? So answer would be 1 and 2 only. Now, digital election campaigns and regulatory gaps in India. Digital election regulation, what is happening? Recently, election influencers shift from parties to candidates to the more social media influencers, right? And the concern arise for free and fair elections, a core democratic principle is part of the Election Commission's constitution's mandate. This is happening. Regulation is morely for the candidates and the party, but we see now the election advertisement is more transferring to the digital content creators, right? So that is there. More, it was in the Bihar pre-certification of the political advertisement was asked by the Election Commission. Now, related data, if I tell you, analysis of Bihar Assembly election, Meta Ads Library shows 55 advertisements spent more than 1 lakh on digital political ads on the final month of the elections. Only 23 were official political parties or candidates. That means 32 were the third party actors. And now third party actors are out of the regulation, and this is the issue, right? Impact asymmetry, if I tell you, nearly twice the impression of the parties, the private parties, they gather more impressions than the party and candidates. So that is the demographic reach. About 75% of digital political content was consumed by the age group of the people 13 to 34. That means they are the potential vote banks, right? So for that, what need to do is, first of all, reconceptualize the electoral stakeholders by formally recognizing third-party digital campaigners and intermediaries to expand the powers. Okay, strengthen campaign finance transparency by mandating disclosure of expenditure incurred on the behalf of parties and candidates, not just by the parties and candidates. Ensure legal consistencies. For example, Supreme Court in Secretary Ministry of Information and Broadcasting versus MS Gemini TV 2004 stated that no individual or entity may publish political advertisement benefiting a party or a candidate to digital political advertisement, right? Adopt a life cycle based regulatory approach. Do not limit it just for the campaign period or for the last day. Enhance institutional capacity of the Election Commission of India to check on these issues, right? So prelims question, consider the following statement about digital election campaigners. The ICI requires pre-certification of political ads. Third party advertisers are fully regulated under RPA 1951. No, they are not regulated. Disclosure of social media expenditure is outside the mandate of RPA 1951, right? So this is there. They're asking for which of them are not correct. So 2 and 3 are incorrect answers. Okay, that means ECI requires pre-certification of political ads. That is there. Pre-certification of political ads was asked by the Election Commission of India, right? Now, mains PYQ. To enhance the quality of democracy in India, the Election Commission of India has proposed electoral reforms in 2016. What are the suggested reforms and how far they are significant to make democracy successful? In this, you can always add this new dimension. That what about the digital content creators, those who are outside the definition of political parties and candidates, right? Discuss the regulatory deficiencies in governing digital elections campaigns and evaluate reforms needed to safeguard electoral integrity and fairness. Based on that, try to write this answer. Okay, now we'll be moving to international relations, and very important development is that India RCEP minus China strategy. I am sure you are aware that India opted out from the RCEP because of its issues, and now the thing is that more than 6 years after opting out of RCEP, India has secured most economic benefits of the bloc without formally joining it. So it's a big win for Indian diplomacy and economics. With the conclusion of India-New Zealand FTA 2025, the most recent one, India has now FTA with all RCEP members except China, which is reflecting a calibrated trade strategy. Right? Outcome with this, that without systematic vulnerabilities and loss of tariff sovereignty ke bina, we have just got this FTAs with all RCEP members except China, because India never wanted to have an FTA with China at the present situation. Right? Expert view it as a smart risk management. All right. Now let's see. Before 2014, India has the FTA with ASEAN, Japan, South Korea, but this led to the rising deficit, especially with the ASEAN, and this is one of the prime reason why India don't want to go for the RCEP. Post 2014, India signed with Australia and New Zealand, completing coverage except China. Okay, now what are the challenges and way ahead? First of all, we have to rebalance the legacy FTA where we have a very high fiscal deficit, and also boost domestic manufacturing competitive, make in India Atmanirbhar Bharat, so that we will become more competitive in the foreign markets and we can tap the benefits of these FTAs. Leverage FTAs for supply chain diversification from China. Okay, what is RCEP? A quick revision. It's a 10 ASEAN countries: Australia, China, Japan, South Korea and New Zealand, in addition to the 10 ASEAN countries. It covers 30% of global GDP and population. India opted out first because of the China factor, risk of Chinese goods flooding into the Indian markets, manufacturing asymmetry between India and China, trade deficit concern, especially with ASEAN and China, and also weak safeguard, for example, inadequate protection of agriculture, MSME and manufacturing, limited flexibility in tariff timelines. That is why India opted out from the RCEP, but now more or less these benefits have been achieved by the India without signing the formal RCEP agreement, right? Now look at this RCEP, consider the following statement. RCEP comprises 10 ASEAN countries along with Australia, China, Japan, South Korea and New Zealand. Okay, this is a correct statement. It accounts for about 30% of global GDP and population and aims to tariff liberalization and supply chain integration. This is a correct statement. India opted off RCEP mainly due to concern related to the trade deficits, manufacturing asymmetries and inadequate safeguard mechanism. All right. Now mains PYQ, based on the organization, it is very common. I2, U2 was asked there. Now evaluate India's RCEP minus China strategy and its implication for trade policy. This is an application based question. Try to write it down. I have given you this background that India has achieved all the economic benefits of the RCEP without signing the RCEP. That means India has shed away all the threats that was in the RCEP agreement, because Indian markets could have been flooded by the Chinese goods as all. Okay. Now recently, you know that Bangladesh in flux, recent political turmoil is happening in Bangladesh and it is gripped by widespread violence and political unrest since mid-2024. However, signs are pointing that it was a planned regime change operation rather than a spontaneous uprising. Okay. Now Jamaat-e-Islami has emerged as a key power broker in Bangladesh and pushing an agenda that challenges the post-1971 political order between India and Bangladesh, and this is the issue of concern for India. What India should do? Like we did in Afghanistan, India should reassure the Bangladeshi people, continue humanitarian aid, trade and engagements, and signal goodwill beyond regimes, right? Push for inclusive elections, advocate free, fair and inclusive election involving all major parties, strategic restraint with engagement. This is a diplomatic smart tightrope diplomacy, balanced question with dialogue, recognizing Bangladesh centrality to the India's regional security and neighborhood first policy. All right. So conclusion. Bangladesh current turmoil marked by political Islamization, economic stress and anti-India rhetoric pose direct threat to strategic security and economic challenges for India, making stability and inclusive policy in its neighborhood very, very important, right? So this is the key features: dismantling of post-1971 consensus, because there's anti-India rhetoric very much. Minority repression and Islamization is taking place in the Bangladesh. Mobocracy and media suppression is very much visible. Rising anti-India rhetoric. So, but why Bangladesh is important for India? We know the largest land border that we share is with Bangladesh. Secondly, it is important for our internal security and border management also. And strategic risk post-2020 reports: renewed Pakistani military influence near the India-Bangladesh border raised serious security concerns. Okay, so there was a mains PYQ. For example, India is an old age friend of Sri Lanka. Such sort of questions you can expect, and we have to wait for like how these things would be unwrapped in coming days. In a rare snowfall, Saudi Arabia's northern desert, okay, which is known as warming paradox. What happened? So first of all, Tabuk and Al Jaf, you please remember these places in news, very important for the prelims. It is in Saudi Arabia. They have witnessed a snowfall, okay, very heavy snowfall, but this is not the very first time. Before that, 1992 and 1973, also they have witnessed an precipitation in forms of ice or snowfall, right? Snowfall in northern regions, especially higher elevation, has experienced because of this in the past as well, and this is known as the warming paradox. What is warming paradox basically? First is that if you see, Arab region is warming almost twice of the global average as per the WMO reports, right? This leads to the warming paradox. That means a warmer atmosphere holds more moisture, increasing the likelihood of intense and extreme weather events, including rare snowfalls. This is known as warming paradox. So they may ask you, what do you mean by warming paradox? You may think it is Arctic, but it is more about the Arab region, right? Now, why snow occurs in Saudi Arabia? First of all, high altitude region, and also atmospheric condition. For example, cold air masses from Mediterranean occurs on northern regions that can push temperatures below freezing points. When the cold air currents meet from rain-bearing system, the precipitation may take place in form of ice. Apart from the Saudi, there are some other instances also. For example, Sahara deserts in Algeria, Atacama desert in Chile, and Mojave deserts in US have experienced the snowfall previously as well. All right. Now let's see the prelims question. Saudi Arabia recently witnessed a snowfall in regions such as Tabuk and Al Jaf, with the temperature dropping to minus 9.3 centigrade. Okay, reason? The unusual snowfall has been attributed to warming paradox, wherein global warming contributes to the extreme and atypical cold events in certain region. And answer is both statement A and R are true, and R is the correct explanation of A. Okay. Now, Trump administration pauses immigration from 19 high-risk countries. Now, after President Donald Trump pledged that he will permanently pause migration from all third world countries, it has started that all immigration applications from 19 designated high-risk nations has been stopped in US, right? Extension of previous travel ban. Finally, previously it was banned from 12 security and restricted access from 7 other due to national security concerns. Earlier, the ban did not affect immigrants already in the US. But now this has been changed as well, and there's a full review of those who entered and after January 2021. Trump's wider immigration crackdown is the agenda beyond illegal migration to strict limits on legal migration as well. Right? His administration urges immigration harms US workers and poses national security risk. Critics say claims are exaggerated or false. Right? Criticism is that experts believe that US already has one of the world's most difficult, rigorous immigration vetting system, right? Secondly, by doing this, it will reduce the US workforce by 6.8 million by 2028 and by 15.7 million by 2035. This will reduce the quality of life and also reduce the long-term economic growth in the US region also. All right, now let's see the prelims question. Consider the following statements about the US migration pause. It affects 19 high-risk nations. It affects the gold card visa program. As per the reports, it will significantly improve long-term economic growth of the US. So this is correct. It is not under gold card visa program. That is a separate thing. We'll just discuss in a minute. Per the report, it will significantly improve. No, it will degrade the quality irrespective of the promises made by the Donald Trump administration. As per the expert, it will reduce the long-term economic growth of the United States. So answer would be 1 only. Right. So diaspora is an important theme in the examination. So you please keep track of this news and try to answer this question. Now, India-Russia logistics agreement. Days after President Putin visited New Delhi, Russia has signed a law into the reciprocal exchange of logistics supports agreement with India. Okay, so what is this? There's a process for movement of troops, warship and military aircrafts between India and Russia and providing mutual logistics support. So this is a big achievement in this between the two countries. It enables reciprocal airspace use, port calls, refueling, repairs, maintenance and other support during deployments. All right. The framework applies currently to joint military exercises, training, as well as humanitarian assistance and disaster management. But the important point is that with mutual consent, this provision can be used in other operational scenarios as well. Right? So what is the strategic significance for India and Russia? So for India, this agreement will give access to Russian air and naval bases from Vladivostok in Pacific to Murmansk port in Arctic. That means enhancing India's operational reach, readiness and sustainment of India origin platforms. Okay, it also complements India's Indo-Pacific strategy by enabling long-range naval and air deployments, right? But for Russia, the pact facilitates access to Indian ports and airfields, strengthening its operational presence in Indian Ocean and supporting its multipolar posture. So it's a win-win situation for both. In comparison to the India-US logistic pacts, India has also signed logistic pacts like Limoa, Comcasa and Becca, but this act is more tailored to India-Russia requirement, while US puts enhanced interoperability, secure communication, geospatial data sharing. Relos focus on reciprocal logistics, access with Russia, broadening India's strategic options. So that is why it is a better option for India, right? So let's see, the New Start TT was asked previously also. So these sort of questions, when it is in the news, appear in the exam. For that, you have to practice a prelims question here. Consider the following statements about the Relos agreement. It is allows reciprocal logistics supports for troops and warships. It is similar to India's Limoa with the US. Okay, yes, it is more similar. Its application is restricted to joint exercises, geospatial data sharing and secure communication only. No, this is not Leos. It is more about the Limoa, Comcasa and Becca. So if they are asking for the not correct, answer would be 3 only. Right? What is the significance of Indo-US defense deals with Indo-Russian defense deals? Discuss the reference to the stability in Indo-Pacific region, and this is what UPSC has asked. Now you can, using this India-Russia logistic agreement, you can also add one validation point. Now discuss the strategic significance of India-Russia agreement for bilateral defense cooperation. You can add what are the strategic benefits from these points that we had just discussed. Okay, the next is Donald Trump's 1 million gold card issue. So Trump administration has finally launched a long-awaited gold card visa program, inviting individuals and companies to invest at least $1 million in US. This aimed to attract global talent. It generates significant revenue for US Treasury and offers a faster and advantageous route compared to the conventional EB5 system, which is more preferred for the Indians. Right? EB5 offers visa comparatively quicker, requires 8 millions to like some 10 millions investment based on product type and location. But what is the key highlights of the gold plan? Now it is more important that the gold plan is a newly launched US program offering permanent residency and a pathway to citizenship in exchange of high value investment. It replaces the EB5 system and designed to draw foreign capital and skilled talent into the US. But who can apply? Individuals must qualify for lawful permanent residency in US. Corporation can sponsor foreign-born employees and also families, spouse and unmarried children under the age of 21. However, they must pay the additional fees. Cost is processing fees is $15,000, which is non-refundable, and then investment gift of $1 million. Additional cost is visa fees and medical exam charges. Benefits that faster processing time, eligibility family members may join, and offers a direct path to US citizenship. So this is all about the gold card scheme by Donald Trump. The question is newly launched gold card visa program recently news is launched by, answer is USA. So remember this. Now very interesting fact is that Australia enforces a under 16 social media ban and become the first country to explicitly ban the social media accounts for the children below the age of 16 years. Okay. Now what is the law mandates? First, Online Safety Amendment Act platform must take reasonable steps to identify users 16 and deactivate their accounts first thing. Block new accounts creation by the children below 16 years of age. Prevent workarounds such as fake birthdays or identity misinterpretation. Right? Have a grievance mechanism to fix error in case someone's account is blocked by mistakes or which is wrongly blocked. So these are the duties of the intermediaries. The shift placed direct responsibility on tech platform to verify user age and enforce compliance, something which is not done yet before. Okay, now what are the key exemptions? There are some exemptions, for example, dating sites, gaming platforms, and AI chatbots. And this is something which has been raised the issue by people, that AI tools have recently been found allowing inappropriate conservation with the minors. Okay, now let's compare with the India and Australia. What is the issue? So in Australia there is a blanket ban, but India is asking for is not restricting, but it is asking for the parental consent and data safeguard. No minimum age for social media use, but anyone under 18 is treated as a child. Platform must implement a verifiable parent consent. However, how this would be done, this is not clear. Companies are prohibited for processing children data in a ways that may harm their well-being, and also platform cannot track, monitor behavior and run targeted ads towards the children in India. So in India, therefore, it is data protection centric, not access restricting, unlike Australia's outright ban for the 16 years, right? Now, previously they were asked which one of the following was the first to legalize euthanasia. Similar on, they may ask which country has enforced a ban on social media use for children under the age of 16, and answer is C, Australia. Okay. Now, India announces $450 million reconstruction package for Sri Lanka. Because the Sri Lanka is recovering from this economic crisis, and at that time cyclone Ditwa hit the Sri Lanka as well. So India has announced a $450 million reconstruction package for Sri Lanka, right? So answer, cyclone Ditwa hit the coast of which of the following country? Answer is D, Sri Lanka. Okay, and India has started Operation Sagar Bandhu to provide immediate humanitarian aid for the Sri Lanka. Like, India is an age-old friend of Sri Lanka. Discuss India's role in recent crisis in Sri Lanka in the light of the preceding statement. So you can add this point also now. That is how you just keep updating your content and your quality of your answers. Now we'll be moving to science and tech. Norovirus. So it is also known as winter vomiting disease, and the cases are rising in United States. It is highly contagious, acute gastrointestinal flu. Okay, major burden is viral gastroenteritis outbreaks worldwide. Okay, infected maybe because of the contaminated water, food, common in closed settings. Symptoms ensure vomiting, diarrhea, abdominal cramps, and nausea. Okay, now novovirus versus influenza virus. If I tell you, it is acute gastroenteritis, vomiting. However, influenza virus causes respiratory flu. Okay, so this is how previously also Zika virus was asked in the news, and also you just prepare about norovirus. It is also known as winter vomiting disease. It is transmitted through the animals. There is a vaccine available for it. Okay, so no vaccine is available for it. They are asking which of them are not correct. So it is not a zoonotic disease, so it is not correct. Answer would be 2 and 3 only. Right? Caller name presentation. Now, Government of India is trying to bring up something. For example, Department of Telecom will soon mandate telecom operators to display the KYC registered name of incoming callers on Indian phone numbers under the caller name presentation system. For this, they will be using the data in the KYC norms of the internet service provider or the companies like Airtel and Jio and others. However, they will not based on the crowdsourced app like Truecallers. Okay, so they will be starting a pilot project in Haryana gradually. Nationwide rollout is expected in March 2026. Okay, initially it would be started with the 4G and 5G, later expanded to older networks also. Right, now tensor processing unit, like you have heard of CPU, then GPU, and now we have the TPU, that is tensor processing unit. So Meta is in advanced talks with Google to use TPU. Hota kya hai? It's a specialized chip that to accelerate AI and machine learning tasks. Right, data centers and AI cloud. This is used Google Chrome, Google Search. For this it is used optimized for processing large data sets much faster than that of CPU and GPU. And it is massive parallelism. That means it can go for many calculations at work at once. High performance with lower power consumption. So this is all. We just have to wait for the development of this, and till that time just understand that TPU is the faster than CPU and GPU. Right, Center for Chronic Disease. It's an independent, not-for-profit biomedical research organization based in New Delhi, and its objective is to reduce the burden of chronic diseases in India as well as low and middle income countries through surveillance, capacity building, and training and research. All right, it works especially in cardiometabolic diseases, nutrition research. Right, so let's see. Center for Chronic Disease. Consider the following statements. It is a not-for-profit biomedical research organization based in New Delhi. This is a correct statement. It focuses on reducing the burden of chronic non-communicable diseases, particularly cardiometabolic diseases, through surveillance and translation research. That is also correct. It functions as a statutory body under the Ministry of Health and Family Welfare. This is an independent body, right? So answer would be 1 and 2 only. Now, blue tongue virus. detected in North Ireland, right? It is infectious but non-contagious vector-borne disease, and domestic and wild ruminants, especially sheep, are the most affected one, right? Okay, distribution is worldwide, so it is not zoonotic. Human risk is not there. Meat and milk is safe, but it is fever, fecal tongue swelling, nasal discharge, lameness, and bluish tongue. No specific treatments. Vaccines are available for some strains. This is must. You must remember. What do you understand by blue tongue virus? They may ask in the exam. They have asked for H1N1 in the exam. Okay. Now AV spray 10C. Avionics drones, a Chennai-based deep drone company, has recently launched its latest agriculture innovation, which is named as AV Spray 10C. So what is it? It's ultra compact agriculture spraying drone. Bag size packed 53% smaller than the conventional agricultural drone. Coverage is very high, 5 acres per battery charge, precision spraying. Okay. Lower capital and operation costs, suited for FPOs and rural entrepreneurs. So based on that, climate smart agriculture is always in the news. It will be in the exam for sure as well. Prelims question: AV Spray 10C recently seen in the news refers to ultra compact agriculture spraying drones designed for precision crop spraying under Indian field condition. AI based satellite system, chemical pesticides formulation, a government subsidy scheme. So answer would be A only. Right now, fluoride. Recently, in Odisha's Mayurbhanj district, excess fluoride in drinking water is causing widespread fluorosis in several villages. What is fluoride? It is highly reactive, hence not found in free in nature. Present in traces amounts in the human body, and it is beneficial in small quantities. Okay, essential for teeth and bone strength. 99% of the body fluoride is found in teeth and bones only. Excess effects cause dental fluorosis and skeletal fluorosis. This is the issue. And now in the drinking water in the Mayurbhanj, Odisha, this is increasing. Right. So UPSC has all previously asked such sort of questions as well. Now we have another PYQs, and before that, let's see GLP-1 drug. Recently, the World Health Organization has finally issued global guidelines on the use of popular glucagon-like peptide-1 drugs for weight loss. Very much in the news recently. So it's a drug for type 2 diabetes. It also used to treat obesity. Okay. How it works? They mimic the gut hormone GLP-1 release after meals. They mimic. Okay, you have not taken the meal, but you have just taken this drug, and this will mimic GLP-1 release, and it is mostly injectable. Examples includes a dual GLP-1 GLP agonist. Okay. Now, mechanism is that it increases the insulin glucose dependent, decreases glycagon, slows gastric emptying, and increases satiety, leading to the weight loss. So many of the people are using this GLP-1 drugs for the weight loss. Okay. So generally, it is not very have injurious effects on the health. The basic issues like common nausea, vomiting, and diarrhea, rare pancreatitis, thyroid risk, not safe in pregnancy. Okay. Now, the next is Alaknanda galaxy. Researchers at National Center of Radio Astrophysics at Tata Institute of Fundamental Research has found something very interesting, and they have named it as Alaknanda. What is this? It's a spiral galaxy about 12 billion light years away from and has textbook spiral structure. That means, and it has named as Himalayan ribbon Alaknanda. Well-defined spiral arms wrapping around a bright central bulge spanning approx 30,000 light years in diameter. So it is so huge. Star formation 60 solar masses per year. Can you imagine? We closely resemble with Milky Way, but formed when the universe was 10% of its present age. Right? Discoveries observed using the James Webb Space Telescope. Now, spiral galaxies have a central bulge of older stars, often containing a supermassive black hole surrounded by a flat rotating disk with spiral arms. These arms are rich in gas, dust, and young bright stars. About 2/3 of spiral galaxies, including the Milky Way, is the central bar structure. Okay, now let's have a prelims question. Alaknanda recently in news is the best described as spiral galaxy discovered using the James Webb Space Telescope located at around 12 billion light years away. Is it an elliptical galaxy, dwarf irregular galaxy, or a bad spiral galaxy? It is a spiral galaxy discovered. Answer would be A. Right? Hemorrhagic septicemia. 10 black bucks have died in Jharkhand, Jamshedpur in Zoological National Park due to suspected hemorrhagic septicemia. Now, it is a bacterial disease, okay, of cattle and buffalo. Youngs are more susceptible to this. Nature is acute, highly fatal, and also favorable conditions are humid and waterlogged areas. Transmission is through by inhalation, ingestion via contact, or contaminated feed and water. Vaccination is there early for intranervous antibiotics reduce mortality. right? Now, let's see the prelims question with reference to the hemorrhagic septicemia. Consider the following statements. It is an acute bacterial disease primarily affecting cattle and buffaloes, with young animals being more susceptible. This is a correct statement. The disease is based on the Pasteurella multocida, which is a bacteria. That is correct. It spreads mainly through insects, vectors, and occurs predominantly in the arid region. No, it is in more humid and waterlogged region. So this is an incorrect statement. Answer would be 1 and 2 only. Right now, the cosmic filament. This, please remember this term. University of Oxford researchers have roughly reported a 50 million light years long cosmic filament containing at least 14 galaxies. So what are they? The largest thread-like structures in the cosmic web, made up of galaxies, gas, and dark matter, and they generally use as a gravitational collapse or intersection of the matter sheets link galaxies cluster, surrounds cosmic voids, and acts as a highways for gas and galaxies. Okay. So for that, you have a question. Consider the following statements about cosmic filaments. They are thread-like structures of galaxies and gas. That is correct. They span hundreds of millions of light years. Correct. They are part of the cosmic web. This is correct. Answer would be 1, 2, and 3. The next we have is India International Science Festival. It was held in Panchkula, Haryana. Aims to promote public engagement with science and collaboration among scientists nationally and globally as well. Organized by Ministry of Earth Sciences, coordinated by Indian Institute of Tropical Meteorology. Okay, theme was Vigyan se Samruddhi for Atmanirbhar Bharat. Focus areas, ecology of northwestern India and the Himalayan region, science for society and education, Atmanirbhar Bharat through science and technology, biotechnology and bioeconomy, integration of traditional knowledge with the modern sciences. Okay, so just remember this fact. Now next is Doppler weather radar. Recently, Minister of State for Earth Science informed that there are currently 47 Doppler weather radars across the country to survey weather patterns and forecast. What is DWR? Doppler weather radar. It's a specialized radar using a Doppler effect to measure velocity and movement of precipitation and the atmospheric particles, providing position and motion data of the weather systems. How it works? It emits radio waves. Okay, remember radio waves that scatter after striking raindrops and cloud and pass the signal returning to the radar. That time defines the distance. Okay, we know distance is equal to speed, time. Okay, so this delay determines distance, while the Doppler frequency shift reveals the directions of movement of weather system, right? So basically you will find scatter, the distance, the time that is there, based on the time that is the radio waves are taking to come back is used to find the distance. Type of weather radar bands, it used both long S-band, C-band and X-band. That means short, medium and long range radars are used. All right. Tracking weather system and cloud bands, rainfall estimation, early warning systems, it is used for these purposes. Now, with reference to Doppler weather radars in India, consider the following statements. Doppler weather radars use the Doppler effects to measure the velocity and movement of precipitation and atmospheric particles. Right? So, this is a correct statement. The Doppler frequency shift helps determine speed and directions and weather system, while time delay indicates distance. This is correct. The Doppler frequency shift determines the speed and direction of the weather system, and while time delay indicates the distance between the antenna and the weather system. Doppler weather radars operating S-band, C-band and X-band frequencies. So yes, that is also correct. Answer would be 1, 2 and 3. Now, Development, Communication and Information Dissemination Schemes. Minister of State, Information and Broadcasting informed the Lok Sabha that Development, Communication and Information Dissemination Scheme is all about, it's a central sector scheme under the Ministry of Information and Broadcasting, and its objective is to publicity of the citizen-centric programs and outreach of the government programs. Okay. Coverage, rural, tribal, remote and urban population. Implemented by Central Bureau of Communication, Press Information Bureau and New Media Wing. Right? That is there. Now, nitrofurans. It was recently in news. FSSAI launched an egg safety drive after nitrofurans presence triggers uproar. What are the nitrofurans? It's a synthetic broad spectrum antimicrobial with furan ring plus nitro group. Okay. Action mostly bacteriostatic, active against gram plus minus bacteria and some protozoa. Earlier used in livestock aquaculture, nitrofurantoin still used in humans for treating UTIs, but it is banned in food processing animal activities and animals, and because it is carcinogenic and toxic. Now it is found in eggs, and that is why FSSAI has started this drive. Now, nitrofurans recently seen in the news in connection with FSSAI egg safety drive are Naturally occurring antibiotics used widely in poultry to enhance productivity. No, this is not there. Synthetic broad spectrum antimicrobial agents that are banned in food producing animal due to carcinogenic potential is the right answer. So answer would be B. Like Dhruva 64 is the first fully indigenous developed microprocessor. 64 stands for 64-bit. It is a dual core 1.0 gigahertz speed designed for efficient multitasking. Okay, and this is the step towards the self-reliance in semiconductor. So please remember Dhruv 64, recently seen in the news, refers to a fully indigenous developed microprocessor, a satellite-based navigation system, a quantum communication system, AI-based threat detection software. Answer would be A. It is an indigenously developed 64-bit architecture. Okay, now Geminid Meteor, if I tell you, it's one of the most spectacular and celestial calendars set to peak this weekend. Named after the constellation from which the meteors appears to radiate, Gemini, right? Origin from asteroids 3200 Phaethon. Please remember that unlike most comet origin shows, origin is from an asteroid. Okay, observation best seen at night from pre-dawn among the most reliable meteor shower. Next is GLOW-Cas9 protein. Recently, scientists from Kolkata-based Bose Institute have created GLOW-Cas9. CRISPR-Cas9, you remembered? GLOW-Cas9 is now the new innovation which tracks gene editing. It's a bioluminescent CRISPR-Cas9 that glows during gene editing. It's Cas9 fused with a split nanolubricase enzyme. When Cas9 folds and become functionally active inside the cell, the fragment rejoin and emit light signaling active gene editing. Okay, so this is important. Real-time non-destructive tracking of gene editing in living cells. It is important. So this could be asked in the exam. Remember, GLOW-Cas9 protein recently seen in the news is a bioluminescent CRISPR-Cas9 system that enables real-time tracking of gene editing in living cells. Answer would be A. Alright. Now, agentic AI. Very understood. Microsoft recently observed that India is witnessing a strong momentum in deployment of AI and agentic AI applications. So what is agentic AI application? Is an agency with the ability to autonomously set goals, plan, decide and act with minimal human interventions. That is AI and an agency, right? Generative AI create content. For example, you are using ChatGPT and Grok. These are generative AIs. Agentic AI is more about such output towards goal-oriented actions by planning, invoking tools and executing tasks by themselves. So planning is they set goals and decompose tasks, execute tasks, calls tools, and they learn from the outcomes and adapt. That is how they just keep growing. Okay, so with reference to the agentic AI, consider the following statement. Agentic AI systems typically combine perception, reasoning, planning, action, and reflection in a single workflow, right? The distinguished features of the agentic AI lies in the ability to invoke external tools and API to execute tasks. Agentic AI operates only in offline environment and does not interact with external systems in real time. This is an incorrect statement. Answer would be 1 and 2 only, right? Now, dieback disease. The withering of thousands of neem trees over some years promoted the Mulugu-based Forest Research College and Research to launch a comprehensive scientific probe into a devastating dieback disease. Now, what is this disease? This is causing progressive dying of twigs and branches from the tips. Please remember, from the tips it started. It's a fungal disease. Okay. Symptoms: tip to base browning, wilting, twig death, fruit seed loss. Severe infections can cause near total fruit loss and large-scale tree mortality. Right, so dieback disease recently seen in the news refers to a bacterial disease affecting livestock. No, a fungal plant disease causing progressive drying of twigs and branches, often worsening underground and moist condition. Answer would be B. Okay, the next is Anato. So CSIR has informed that CSIR CFTRI Mysore has undertaken 4 grant and 8 projects related to the study and development of Annatto. Now, what is Annatto? It's a natural food coloring and flavoring agent derived from the seeds of Achioto tree that is native to tropical Americas. Okay. Key characteristics is that it's a yellow, orange, red color due to carotenoids, pexin, nor pexin. Alright, uses color cheese, butter, yogurt, sauces, smoked fish, ice cream, and baked food. 70% of the natural food colors. Okay. Promote health, it has antioxidants, antimicrobial, generally safe, rare allergies are found. So please remember the term. Now, Antariksh Prayogshala, also known as Space Labs. So Indian National Space Promotion and Authorization Center, that is InSpace, has recently rolled out a request for proposal to establish Antariksh Prayogshala, that is Space Labs, in select administrative academic institutions across India. Okay. So what is this about? They will try to set up space laboratories in academic institutions for hands-on space tech training. Coverage is up to 7 institutions, 1 per geographic zone, phased-wise manner. Now, what are the users? Students, non-government entities in the zone. Okay, funding. InSpace will support up to 75%, cap up to 5 crore per institution, milestone linked. Okay, selection will be carried in 2 stages, eligibility screening and empowered committee ranking. What is InSpace actually? It is an autonomous single window agency under Department of Space, and it tried to enable the private sector participation in the post-space reforms. Right? It authorized, promote and supervise non-government entities' space activities, role interface between ISRO and NGE, optimize use of India's space resources. Alright, now consider the following statement about Antariksh Prayogshala. It is initiated by InSpace. It aims to set up labs in academic institutions, initially limited to government agencies, gradually allowed to students and private entities as well. Be aware of such sort of statements. It is not correct. Answer would be 1 and 2 only. Right? Now, autophagy. Researchers have uncovered a surprising player in autophagy process that can pave the way for developing therapies, disease such as Alzheimer's, Parkinson's and cancer. Very important development. What is meant? It's a cellular self-healing recycling mechanism that removes damaged organelles, proteins and pathogens. Core functionalities is to break down cellular waste and reuse components to maintain cellular homeostasis. Okay. Significance. It will prevent waste accumulation, crucial in long-lived cell-like neurons. Protects against infections, destroys intracellular bacteria and virus, supports cell survival during stress, aging and nutrient scarcity. Right? Disease link, if it would be helpful in tumor suppressors in early stage, so cancer, it would be helpful. Neurodegenerative diseases, for example, disrupted autophagy leads to accumulation of damaged proteins in Alzheimer's and Huntington's disease. So that will be very important development. With reference to autophagy, consider the following statements. It is a cellular mechanism that removes damaged organelles and proteins to maintain cellular homeostasis. Proper functioning of autophagy is particularly important in long-lived cells such as neurons. Disruption of autophagy has been linked to neurodegenerative disease such as accumulation of damaged proteins. So all 3 are the correct statement. Answer would be 1, 2 and 3. Now, ghost pairing, another term. It is certain has issued an advisory which targets WhatsApp user by using a new technique called ghost pairing. In that, a person, external entity, will take over your WhatsApp account and abusing by the device linking pairing feature, which attackers link your device with their own without password or SIM swap. What they do? They just used to send you a phishing message. Maybe click on this photo or some link, and when you open it, you will enter your name, mobile number, and OTP. And with this, the person will take the access of your WhatsApp account without even the awareness of the user. Impact full access to the chats, media, and impersonation, while victim remains unawareness of these terms. Okay. So remember, ghost pairing recently in the news refers to it's a social engineering attack that exploits WhatsApp device linking features to secretly link an attacker's device to victim's account. With this, the attacker will get the access of all your contents, chat, images, and everything in the WhatsApp. Micrometeoroids and orbital debris. So recently, what happened? China's crewed vehicle Shenzhou 20. They caused a minor crack in the windows. It is a return capsule which raised the concern regarding the protections of astronauts from micrometeoroids and orbital debris in the orbit of the Earth. Now, what are these two? Micrometeoroids are natural particles. Okay, this is very small and particles of rocky or metallic matters moving through the space. Right? This is asteroid belt collision. Minor contribution comes from the comets. Speed is 11 to 72 kilometers per second. Right? Impact billions of hits on orbiting spacecraft annually. So that means wear and tear is there. Orbital debris is the man-made objects in the Earth orbit. For example, they do not longer serve any functional purpose. For example, exploded rocket stages, defunct satellites, collision and the debris from the anti-satellite missiles. Okay, speed is about 10 kilometers per second. Concentration mainly in the low Earth orbit. Right? Now, recently, understand, Shenzhou 20 recently seen in the news is the context of concern led to micrometeoroids and orbital debris is associated with which of the following space agencies? JAXA, China National Space Administration, NASA, Russian Federation. So answer would be China National Space Administration. Alright. T. Chameleontes and astronomers use archival spectroscopic data from NASA's James Webb Telescope mid-infrared instrument to study polycyclic aromatic hydrocarbons in the spectrum. Now, what is this? This is a young sun-like star in the Chameleon constellations, 350 light years southern by the sky. Now, key features: circumstellar disk with a wide gap, unlikely due to forming planet. Significance, ideal laboratory to study early planet-disk interactions. Okay, so very important again. Now, what is polycyclic aromatic hydrocarbons? It's a flat ring-shaped carbon-hydrogen organic molecule delivered to Earth by the meteors, aiding prebiotic chemistry. Okay, in space, it constitutes about 20% of the interstellar carbon. Right? Properties: low water solubility, high lipophilic, that means strong affinity to the fat, soluble in organic solvents. All right. Now, frequency comp. Frequency comps are important modern tools which are used to calibrate atomic clocks and various other applications. It is a laser source. Okay, spectrum used to thousands of equally spaced phase coherent frequencies, something like this. Okay, and it resembles like a comb. It bridges radio and optical frequencies. It is very, very precise, and it is used in atomic clock calibration, precision spectroscopy, exoplanet detection, and measuring gravitational effects on the light. Okay, so this is the frequency comb. Candida auris recently discovered a genetic process which could unlock new ways to treat mysterious and deadly Candida auris. What is this Candida auris? It's an emerging multi-drug resistant fungal pathogen. It's a multi-drug resistant fungal pathogen. Is healthcare associated, contaminated surfaces person to person. Risk is hospitalized, comorbid patients, invasive species. So colonization, invasive infection, persistent fever, mortality chances are 30 to 60%. Treatment is echinocandins. Resistant strains may need combination therapy. All right. Next is the MAVEN mission. NASA has lost contact with its Mars atmosphere and volatile evolution, that is known as MAVEN spacecraft. This was a Mars orbiter mission that has worked for more than a decade to study how the planet's atmosphere is evolving and escaping into the space. Now China has NASA has lost the contact with that agency. NASA has launched in 2013, aimed to study upper atmosphere of the Mars and atmospheric loss to the space. Okay, it was an orbiter mission. Now the findings is that Mars has lost 2/3 of its early atmosphere to the space. Okay. Now, with reference to the MAVEN mission, consider the following statements. MAVEN is a Mars orbiter mission of NASA, launched to study the upper atmosphere of the Mars and its to lost space. Okay, this is a correct statement. The mission has provided evidence that Mars lost a significant portion of its early atmosphere over time. MAVEN was designed to primarily study the surface geology and mineral composition. No, it was an orbital mission. So, answer would be 1 and 2 only. Right. Now, ELA is IIT Delhi researchers have recently developed an AI agent, that is artificially intelligent lab assistant. Okay, it is an autonomous agent, performs real-time lab experiment end to end, very important. Directly operates instruments like atomic force microscope, which is world's most delicate and complex instrument used in study materials for the nanoscale. With this has reduced the time from 24 hours to 7 to 10 minutes. That's all. Fully automates experiments, codes, data collection, analysis, and decision. So it has increased the outcome. Now, buccal mucosa cancer. Alcohol consumption even in the small amounts. Please be aware, alcohol consumptions even in the small amounts significantly increase the risk of buccal mucosa cancer, a common and aggressive form of oral cancer in India according to the recent studies. It's an oral cancer arising from the inner cheek lining, mostly squamous cell carcinoma. It is the most common oral cancer in the Indian subcontinent because of this tobacco and alcohol. Right, treatment, surgery plus radiotherapy, chemotherapy based on the stage. Early detection is crucial, 60 to 70%, 5 years survival, oral cavity cancer rates. Okay, now with recent studies indicate that the alcohol consumptions even at the low levels increase the risk of buccal mucosa cancer. Right, inference, alcohol may contribute to oral carcinogenesis by altering the local cellular environment of the buccal mucosa. Which of them is the correct statement? Both of the statements are correct, and the reason inference is valid explanation of the statement. Okay. Now, LVM-3 M6 mission. ISRO launched the LVM-3 rocket carrying the heaviest ever satellite known as Bluebird Block 2. Remember this name. Payload, it was some around 6,100 kilograms, heaviest by the ISRO. Market, AST Space Mobile of USA. Orbit, lower Earth orbit, it was purported. Okay, purpose was to direct 4G, 5G connectivity to normal smartphones. Right, it will significantly boost India's commercial launch capability and global satellite broadband. Right, the next is superkill nova. Astronomers have discovered that the first example of explosive cosmic event called superkill nova in the form of gravitational wave signal. What is superkill nova basically? So it's an extreme cosmic event combining a supernova, that is a massive star death, and a kilnova, that's a neutron star merger. Okay, so kilnova versus super kilnova, if I tell you, kilnova is a merger of two pre-existing neutron stars, whereas super kilnova starts with a supernova, then ends it in a neutron star merger. Okay, it creates heavy elements like gold and silver and emits gravitational waves. Right, so super kilnova, recently seen in the news, refers to, it's an external cosmic event that begins with supernova and culminates into neutron star merger emitting gravitational waves. This would be the correct answer. Alright, Respond Basket 2025. So recently ISRO has released Respond Basket 25 listing research problems, standards aligned with its ongoing future mission needs, so that inviting academia and research institution to contribute. Okay, objective is align academic research and development with ISRO's current and future mission needs. Quantum computing, launch vehicles and material remote sensing, advanced facilities and communications are the primary requirement. Mission linkage, Bharatiya Antariksh Station, Chandrayaan 4, Gaganyaan, Venus Orbiter, Human Moon missions. These are the missions in line. Who can apply? Faculties, scientists from recognized academics and autonomous research and development institutions can apply. Right. This is the major development, quantum echoes. Google's recent quantum echoes experiment 65 qubit Willow processor makes a shift from chasing quantum speed to understanding how information evolves and entangled in quantum system. That means, abhi tak what was happening, that people were trying to chase the quantum speed. Everybody wants to run systems based on the very high speed quantum, but now they have changed. Now they want to understand how things are working in the quantum environment, how information is being processed, how it is being transferred. Right, it is an experiment that tracks how quantum information spreads, scrambles and partially refocus between the entangled system of the qubits. Right, significance, it will reveal quantum chaos and informational flow useful for physics and material sciences. So consider the following statements regarding Google's Willow quantum processor. It's a 65-bit qubit processor that marks a shift from chasing quantum advantage to building useful quantum system. The processor demonstrates information evolving in entangled quantum system. Both of them are correct answer. Answer C would be the right. Now, we'll be moving to the last section for today, that is the culture part. Recently, India has been re-elected to the UNESCO Executive Board, right? So, Executive Board is one of the three constitutional organs of the UNESCO, the other being the General Conference and the Secretariat. It's the decision-making body and supervisory body, consists of 58 members with each a 4-year terms in the office. It acts as a bridge between policy formulation and implementation, plays a crucial role in shaping global norms related to the education, heritage and freedom of expression and scientific cooperation in the UNESCO framework. Key function, it examines and approves UNESCO's program for work and budget, supervises the executions and program adopted by the General Conference, recommends the appointment of the Director General of the UNESCO, reviews reports of the UNESCO's activities and the financial management. That means it's a very powerful body. Now India has become a member of it. Now with reference to the UNESCO Executive Board, remember it is one of the three constitutional organs of the UNESCO. Correct answer. It elected by the UNESCO Secretariat. No, it is elected by the General Assembly. It consists of 58 members. States search each for 4 years, examine and approves UNESCO program for work and budget before submission to the General Conference. So answer would be 1, 3 and 4. Now, Perum Bidgu Muthariyar 2. A commemorative postage stamp in honor to the King Perum Bidgu Muthariyar II was released by the Vice President of India, and he was also known as Suvarn Maran, was a ruler of Muthayar lineage, feudatories of the Pallavas. He is believed to have fought bravely in several battles along with the Pallava king Nandi Varman. Okay, so they were ruled from the time of Parmeshwara, one of the Pallavas dynasty, as they were the feudatories of the Pallavas. They are also known as the greatest temple builders. Okay, now Bison Horn Maria Festival, recently celebrated in the Jaduapura in Bastar, Chhattisgarh. It's a vibrant folk dance performed by the Dandami Madhya, also known as Maria tribe. The communities identify itself with a larger Gond tradition. Okay, performed by both men and women. Men wear horn-shaped headgear made from bamboo, adorned with the bison's horns, feathers and bright cloth strips. Women wear bright hand-woven saris, heavy silver and brass ornaments and headgears. The dance derives its name from the bison horns, gore horns worn by the dancers, and that is why the name is Bison Horn Maria dance. It mimics the movements of wild bison, representing strength, vitality and the tribe's deep connection to the forest life and hunting tradition. Okay, ritual chants during the performance often invokes local deities like Buddha Dev and Danteshwari Mai. So consider the following statements about the Bison Horn Maria dance. It is performed by Dandami Madhya tribe from Chhattisgarh. Which of the following are correct? Both of them are correct. Answer would be C. Okay, so remember this. These sort of folk dances are important for your exam. Now, 150 years of Vande Mataram. India celebrated 150 years of national song Vande Mataram, a hymn that has inspired generations with the message of devotion, unity and patriotism. Right? Composed by Bankim Chandra Chatterjee in Sanskrit, first appeared in the literary journal Banga Darshan, and it was later incorporated into the landmark novel Anand Math. Right? The song was first sung by Rabindranath Tagore in 1896 Indian National Congress session in Kolkata. In the 1905, Indian National Congress has accepted it as a song for the Pan-India movements. By the early 20th century, it becomes a song of resistance. Vande Mataram had evolved into a rallying cry for the Indian nationalism. Societies such as Vande Mataram Sampradaya tried to promote this song through the public procession known as Prabhat Feri. British administration tries to suppress its influence, influencing fines on the students and banning its public recitals. Okay, in 1950, the Constituent Assembly of India officially recognized Vande Mataram as the national song, honoring it alongside with Jana Gana Mana and the national anthem. But please remember that only the initial 2 stanzas are recognized as the national song of India. Let's look at this question. Consider the following statements about Vande Mataram. It was composed by Bankim Chandra Chatterjee as a preface in novel Anand Math. No, it is an incorrect statement. It was initially a standalone and was put into literary journal Banga Darshan. Right, first sung by Gurudev in 1905 session of INC. It is an incorrect statement because it was sung by in 1896. It was recognized as a national song by the Constituent Assembly in 1950. Which of them is correct? C would be the answer. Okay, now last thing for today is the Periya Vihar temple. India has expressed strong concern over damage to conservation facilities at the Periya Vihar temple complex amid ongoing clashes along the Thailand-Cambodia border. It's a Hindu temple complex located atop of the Dangrek mountains built by the Khmer Empire. Okay, it is also a UNESCO World Heritage Site. Temple is dedicated to Lord Shiva. 2-3 things that you remember. First is the places in news, and also the Dangrek mountains recently seen in the news are located on the lines of border of Cambodia and Thailand. Okay, so with this we bring our discussion to end. Thank you for joining. I hope please just go through this video and it would help you to revise your recital in an efficient manner. With this, I conclude the session. Thank you. Goodbye. Take care.